It does take such great care.
Okay, maybe 6 months ago, we're never making it.
Good morning. I'm sorry that I was a minute late. There were some problems, but all good. So today is Thursday, October 9th, 2025, and the time is 10:05. Thank you all for attending the Peace Officer Standards Accountability Advisory Board hearing. Please note that this hearing is being live streamed, recorded, and transcribed. Further, please note that the microphones are auto on/off. When you begin speaking, they will go live with this, and you will need to watch your crosstalk. We will now call the roll of board members.
Thank you, Madam Chair. Good morning, Board. Clavo,
Present.
Doyle,
Sure.
Crawford,
Here.
Dudley,
Here.
Glacier,
Here.
Johnson,
Here.
Laura,
Here.
Pena. 7 present, quorum established.
Okay, thank you so much. I would now like to introduce Board Counsel Christopher Beatty to my left and Post Assistant Executive Director, who's coming up the aisle now, Anne Maria Delgado. Public comment. So Anne Marie is here, Chris is here. This time is set aside for members of the public who wish to comment on items not on the agenda, but those within the board's jurisdiction. Public comment on matters on the agenda will be heard after each item is presented. Public comment on specific peace officer revocation cases to be heard today will be heard at the time of the hearing of each such matter. Please be advised that the board cannot take action on items not on the agenda and may discuss those matters only to the extent necessary to determine whether any matter should be made an agenda item at a future meeting. To respond briefly to statements or questions posed, to request clarification, or to refer the items to staff. Please remember that this meeting is being transcribed, so I may politely interrupt and ask you to repeat or speak slowly and clearly so your comment can be correctly captured in the transcript. As the board chair, I may ask members of the public to limit their remarks to no more than 3 minutes pursuant to existing board policy. I may conclude the public comment period if multiple speakers are voicing repetitive or similar statements and the 15-minute public comment period has expired. You will be given 3 minutes to speak, and the time limits will be strictly enforced, so please ensure that you complete your thoughts within the allotted time. Before I open public comment on matters not on the agenda, please note if you wish to comment on disciplinary matters scheduled to be heard today by the board, you must wait until that matter is called to offer public comment. If you have a specific complaint about an officer that is not on today's agenda, you should file a complaint with Post or with the officer's employing agency. Staff will assist you in this regard. I would like to remind individuals making comments to not discuss pending complaints or pending disciplinary actions that may later come before the board for recommendation. If the board takes action on the complaint, you will have an opportunity to address the board at that time. Following these rules is necessary to comply with the state law and to avoid compromising the board's mission. So, having said all that, is there anyone present in the audience or appearing remotely who would like to address the board? First in the audience. Seeing nothing, now asking about anyone remotely.
We have 4 online.
Okay, it appears we do have 4 people online. Is there anyone present in the audience or appearing remotely who would like to address the board? First in the audience.
And everybody needs to raise their hand if you want to leave a comment.
Asking about anyone remotely. Okay, you may, I'm not sure if there's anyone remotely who would like to speak, but if so, you have an option. You may state your name and organization if you wish. I'm not sure if there's anyone who would like to speak, but if so, you have an option. You may state your name and organization if you wish.
My name, my name.
Ask him if I can hear you.
Can you hear me?
You might just join on Zoom.
Good morning. For those of you wishing to provide public comment online, if you can mute your live stream so that we can hear you.
Is there anyone who remotely would like to speak? If so, please begin speaking.
Okay. Hello.
Yes, hello. This is Joyce Dudley. I'm the board chair up here at Post at the meeting. Did you want to speak?
Hello.
Please proceed.
Hi, can you hear me?
We can hear you. Please proceed. Good morning.
Oh, sorry. Good morning. My name is Patricia DeArmond. I'm the sister of Christopher DeArmond, who was killed by San Diego Police Department on January 20th, 2023. They racially profiled him. A pretext stop, hot stop, led into a slow speed pursuit. He was shot at excessively 28 times, some of which included non-department issued hollow point ammunition by Officer Jacob Myers. His constitutional rights were violated by Christopher Aguilar, who told him, "Your word means nothing," and Sergeant Rene Murillo, who failed to intervene as acting supervisor on scene. This whole case has been a cover-up. He was left to bleed out on the streets, a river of blood. No CPR or an AED was rendered. A canine was deployed 11 minutes after he was shot, 28 times, including hollow points. SDPD failed Christopher DeArmond by failing to intervene, escalating the entire situation and into a matter that it never needed to be there. My brother asked for his citation. They said no. They violated his rights, antagonized him, and used his background with a little bit of marijuana, which is legal here in California. He had well under the legal amount. They accused him of illegally transporting marijuana, escalated the situation so far he hit into fight or flight mode and panicked. He didn't want to go back to jail. SCPD did not value his life that night. Neither do they value the lives of ex-felons. And these officers need to be held accountable, including Jacob Myers with his hollow points. We had sustained findings with internal affairs and still nothing has been done. Internal Affairs did not give the CPP, the Commission on Police Practices, full case files for the case review. Not my whole complaint was included in its findings. I wrote everything that happened. Why wouldn't it be there? This has been a cover-up. These were evil actions taken by these officers. My family is here with guilt and remorse and horror. This is traumatizing. And these officers, Christopher Aguilar is still allowed to patrol in the same area where he killed at. And he had a rap history of being a bully in the neighborhood. well before my brother was killed by him. And he's still here all the time by Chicano Park. He needs to be removed from Barrio Logan. Christopher Aguilar needs to be held accountable. Jacob Myers needs to be held accountable. Renee Murillo and Patrick Harvey, who this is his second time deploying a canine on a victim that's already been shot after a hot stop was conducted. He had another incident in October 2020 where CHP pit maneuvered a car and the person got off with a gun supposedly, but you don't even see the moment that they shot at the cops like they claim. He might have shown a gun, but they should be telling officers to drop their weapon before they shoot at them. Hollow points need to be banned entirely. CPR and AEDs must be rendered after they've been shot at and wounded, and saying that he's playing possum or faking it and that he could be baiting them into another ambush. He can't move. He screamed, "I can't move." They ordered commands to make him crawl towards his weapon. That didn't make any sense. And when you see the footage, they dragged his body closer and towards his weapon, not away from it like they claim. They say he died while undergoing life-saving medical procedures, but he was shot at 11:38, with shots fired being called by the watch commander 1 and 2 minutes before he was shot. And if he was shot at 11:38, why was he pronounced dead at UCSD at 12:24 when that hospital is 5 minutes away? And why didn't they utilize Barrio Logan Fire Department? If it happened right here in Barrio Logan, that's about 2 blocks away.
Let
They
me
held up the scene
interrupt
for
you.
14 hours.
Let me
Thank you.
interrupt you just for a moment, okay? First of all, I could just hear the pain in your voice. I can't imagine the agony you and your family are going through. I want you to know there is a process, and I'm going to ask the Assistant Executive Director to my right to tell you how exactly to file that complaint or what we can do next in terms of getting someone in touch with you. But let me just say, on a personal level, I am so sorry for your loss. Go ahead.
Thank you so much. My dad already submitted a complaint. Please look into it.
Thank you very much. We
Thank
will
you.
address that, and someone will be in touch with you.
Okay, is there anybody else remotely who would like to speak? There more on the line? Okay. Apparently there are some other folks on the line who would like to speak. I'm not sure why it's not coming through, but please just speak up and we'll take it from there.
Hello.
Yes, I can hear you. This
Oh.
is Joyce Dudley. Please go ahead.
Hi, good morning. My name is Cindy Nunez. My brother was also murdered in March of 2024 by Los Angeles County Sheriff's Department. And I'm calling today regarding the fatal shooting of Christy Arman by San Diego Police Department. I'm urging you, Post, to review the certification of these officers that were involved: Christopher Aguilar, Jacob Myers, and Sergeant Renee Murillo, and also Patrick Harvey, for the severe violations of the Post standards and these basic human rights. Officer Christopher Aguilar actually violated Chris's rights by telling him his words meant nothing, reaching into his car to unlock the door himself, and escalating the situation rather than de escalating. Chris should still be alive right now. That should have never happened. Officer Jacob Myers failed to follow the basic procedures, never requesting Chris's license, registration, proof of insurance that we all will be asked for if we get pulled over at a traffic stop. The use of non-department issued hollow point ammunition. So these officers are going into the station and bringing their own ammunition that's not assigned by the department, increasing the lethality of his actions. Sergeant Murillo, the supervisor on scene, he failed to intervene. He gave misleading statements about what had happened to Chris. He ordered the medics to stand down twice. And also, while Chris was bleeding out on the street. Officer Patrick Harvey, then he deploys a canine on Chris after he had already been shot multiple times, people, and he was incapacitated, and he never gave the order to release the dog, allowing the dog to continue mauling Chris as he lay defensive on the ground. Chris couldn't move. He was not playing possum. If post, as you guys, the board, take a second to compare a suspect, someone being attacked by a canine dog, and they're alert, and you'll see the reaction a regular suspect's gonna have when they're getting bitten by a dog, a canine. Chris wasn't playing possum. He couldn't move. He was dying on them, and they knew that. Chris could not respond to their orders. He was dying. He needed help, and they literally denied him that basic human right. These actions were truly reckless, inhumane, and a direct violation of post standards that you guys certify these officers out there for their officer conduct, accountability, and the preservation of life that they failed to give Chris. I'm urging you, Post, to use your authority to decertify these officers who engage in this coercive, abusive, and retaliatory behavior, and to straighten transparency in how these cases are reviewed. Every abusive officer who keeps their certification weakens the integrity of every good person out there, of the communities. That's why there's so mistrust in officer conduct, because they're doing what they want in the streets, and you guys are certifying these officers. You fail to decertify them and hold them accountable. And I promise you, if you start holding these officers accountable and decertify them, you will get public trust again. You will get community trust. Make an example. Us families deserve protection, not persecution. Please remember that behind every case number, there are people, grieving mothers, sisters, fathers, children. We're all out here fighting for the truth, waiting for accountability that should have been there in the very beginning. Thank you.
Thank you for calling. And I'm incredibly sorry to hear about Chris and the torment in your voice. I'm sure it's unimaginably horrible. So I just want you to know that we heard you, and Post Assistant Executive Director is going to speak now to let you know about a follow-up.
The comment was his response to first caller's remarks regarding the case, that if the complaint has already been filed, Post will be in contact to speak with you about the process and to help you understand what the next steps are in that complaint. If there are other remarks regarding the same complaint, I'm going to ask that we refrain from providing specifics, as it can jeopardize the investigation of that complaint. That Post will conduct that investigation and work with law enforcement agency to procure whatever documents are necessary to do its fact-finding and analysis. So for those of you who are online that wish to comment regarding the same matter, I'm going to ask that we refrain from doing so those specifics are not aired in a public forum that could otherwise compromise the future investigation of the complaint. Thank you.
And again, we want to thank you for calling. Are there any more callers? Okay, if there, I'm happy to hear from you and to hear about your feelings. But at this point, I am going to need to intervene if there's any discussion of the facts of the case, if it's about the same case that we've just heard 2 calls on. So as to the next, please go ahead.
Hello, can you hear me?
I can hear you. Thank you.
This is Mr. Yarman, Christopher's father. I have filed a formal complaint with Post separately against all involved officers and have received no reply.
Let me immediately now turn it over to the Post Assistant Executive Director so she can respond to that, and then I'll continue to listen to your concerns.
Mr. Yarman?
Yes,
So you did file a formal complaint regarding the same matter?
sure did.
Okay. We will definitely follow up with you regarding the status of that complaint following this meeting.
Thank you, ma'am.
You're
Now,
welcome.
let me ask, am I not allowed to speak regarding
You're
the incident?
absolutely allowed to speak. I encourage you to speak. What I'm asking you to do is to refrain from discussing any of the evidence related to the case, any of the facts related to the case. In my prior role, I was the district attorney of Santa Barbara County. So I'm an attorney who understands the value of what you have to say, but by the same token, with that information should not come out in a public comment. It should come out in a formal investigation to best protect Chris's rights. Okay. So if that made sense to you, I certainly want to hear about your feelings. Please try to stay away from the facts. Okay, sir?
Okay, I'll try to. It's going to be
Thank you.
difficult.
I
It'll be
understand.
difficult.
I understand.
Christopher was a father, a son, a brother, and an uncle. He was much loved by his family. The officers failed to use less than lethal nor non-lethal measures in the force continuum that is required prior to execution of deadly force. They took no such actions.
I can't imagine the loss that your family is experiencing, and we will absolutely get in touch with you after this meeting to follow up on the formal complaint, okay?
Yeah, I will also add that I'm a 30-year naval veteran, the former security officer of Naval Base San Diego, and I'm a graduate of the Federal Law Enforcement Training Center, FLETC at Glencoe. I would suggest my training far exceeds the training they received at a local junior college.
I understand, sir, and let me thank you for your service. And I promise right after this meeting, someone will be in touch with you. And again, so sorry for your tremendous loss and the loss for your family.
Okay, thank you, ma'am.
Thank you, sir. Are there any other calls? Okay. Someone else is on the line. Please go ahead. I'm not hearing any voices. Is someone else still on the line? If so, just speak up. If you have a phone or a computer, but you're not unmuting and you'd like to speak, please press the unmute button and speak up. If not, we're just going to go ahead with the meeting and we're going to assume you're just listening to the meeting. So again, an opportunity to unmute and speak up. Okay, hearing nothing, we're going to go on. Okay, we're going to go on to the approval of the minutes. Is there anyone present or appearing remotely or by phone who would like to address the board regarding the approval of the July 16th through 17th transcripts? Hearing nothing. Are there any questions or comments from the board about the minutes? If the, go ahead. Okay, if the board concurs.
Hello, let me know if you can hear me.
I'm sorry, go ahead.
Yeah, something was wrong with the audio. Several speakers were trying to talk. So thank you for taking my call. My name is Bruce Langer, and I'm also calling regarding the shooting death of Christopher DeArmond by San Diego police. I'm calling on post to review.
And sir, I am
Yes.
absolutely going to give you an opportunity to talk, and thank you so much for calling and thank you for bearing with the audio problems. I want to reiterate the concerns of the executive director, the assistant executive director. Please try to stay away from any facts because I don't want to contaminate the evidence of this investigation, but please feel free to share whatever thoughts and feelings you have. Please, sir, go ahead.
I am calling on Post to review the allegations against the officers involved. And I'm wondering also, what is the time frame that Chris's father can expect to hear back from you?
So an acknowledgement letter was sent back in July acknowledging receipt of the complaint. And at that point, it can take several months for us to get additional information from the agency regarding the incident to be able to analyze that information. As soon as we have a
You want to
further
respond?
status update, we can provide that accordingly. If we don't have a good address of record, that may be part of the problem. So we will look into that. Again, I can't give you a firm date. It all depends on the production of documents and the time it takes to analyze those documents. And if there is any follow-up investigation that needs to be done on the part of Post, all of that.
Yeah, this is Mr. DeArmond again. I just wanted your
takes a period of
assurance.
Time. I believe we received the inquiry in July, July 24th to be exact, and a notification of receipt was sent immediately thereafter. So it may take several months before we have a further status update.
This is Mr. DeArmond. Can you hear me?
Yes.
Yes, we can.
I just wanted your assurance that these officers' actions are being reviewed.
I can
Yes, sir.
assure you that the investigation is being reviewed. That is exactly why we're here.
And if he does not hear back from you in the time expected, what is the best way to contact you?
Executive Director.
Yeah, the best way to probably contact any of us, so you can get directly to our complaint intake team to look into the facts of the case, is on the Post website. There's a complaint intake portal, and it's to send a message to request follow-up and a contact. If there's a specific phone number or email address that you wish to be contacted at, you can leave that information through that portal.
Can I leave you my number now?
I wouldn't do that because this is a public broadcast, and I don't know that you want the entire public to have your direct phone number. I think it's probably a safer bet to have you do that through the portal, sir.
Okay, thanks.
You're welcome.
And that concludes my comments. I think there's one more person at least on the line.
Okay, thank you, sir. And we will certainly keep the line open and wait for the next person to speak. We're not hearing any voices.
Can you all hear me?
Yes,
my
now I
phone.
can hear you. Please go
Okay.
ahead.
Hi, my name is Melissa Miramontes, and I'm with United Families for Justice. I'm also going to speak on the family for Chris DeArmond. It's important that the Post, you all have the final authority to be able to allow these officers on the street. I have lost a loved one due to police violence. An off-duty officer killed my brother as well. And I actually filed a complaint against this officer with Post. And Post gave me a statement stating that they cannot look into my request in accordance with California Penal Code 7922535. And it basically they denied my request and said that they couldn't look into it because it was the responsibility of the LAPD. That is false. And I would like you guys to look into the
Let me ask the assistant.
excuse me.
Let me ask the Post Assistant Executive Director to respond to what you just said.
So
Hang on one sec so she can respond to your concern.
Not familiar with that particular provision that we would have responded. It was, it sounds to me like perhaps the response may have been in light of the issue itself falling outside of the 9 acts of serious misconduct. So post is limited to.
Absolutely not.
Okay, so
Absolutely
I
not.
think
This
what I would like-
officer,
Hang on one second, just I promise to let you speak, but I
Okay.
want you to hear the
Sorry
full
about that.
thought of the Assistant Executive Director.
thank you.
We probably will not be able to resolve this over the phone without looking into the specifics of your particular situation. The best thing for you to do then is to file the complaint, refile the complaint for us to look into the assertion that this falls within post jurisdiction, the 9 acts of serious misconduct, and we can respond accordingly. I don't think it's going to be helpful today because I don't have the resources in front of me to be able to address your specific situation. There
course.
again, in a public forum, it's not appropriate to discuss the facts of a case prior to
course.
investigation. So I would ask that you send something to us through the complaint intake portal that we can look
Okay.
into the matter.
Okay,
so
thank you. And I hope to get, I'll try to get the exact email information. You know, the point is, I don't want to, deteriorate from the point is my conversation. The point is you guys have heard several different family members, several different community members here in San Diego who have come together to bring awareness to Christy Arman's story. It's important that Post looks into this. This is one of the most gruesome cases that I have ever seen in my life. I encourage you guys to please investigate, do your due diligence, and please hold these officers accountable in any which way you can. I encourage you all, as you guys start to receive these complaints from community members, because we are definitely going to encourage the community to start filing these complaints after today. Please look into these investigations. My specific complaint number is R002950-050925, filed
one
on May
sec,
9th.
hang on, one sec, just say it one more time, a little slower, so the Assistant Executive Director can write it down.
Okay, thank you. It's reference number R002950-050925. And again, this is not just for my particular case, but all these complaints that you guys are going to be receiving in, please investigate them, do your due diligence. These officers are killing people time after time. Same scenario, same situation, they always get away with it. And the scenarios in which they're harming people, inflicting, and actually, flatly unaliving people,
Okay.
the scenarios are all different. All of our loved ones have been taken in different ways, and yet these officers are not held accountable. There is no way you can rule in the officer's favor time after time when the situations are different. Please investigate. Please do your guys' job. We appreciate your time. Justice for Christy Arman, justice for all stolen lives.
Okay, I
Thank you.
absolutely promise you that is why we are all here.
I
is to
appreciate
look
you
into
guys
these
for having this
cases.
platform.
Also, we've put up information on the screen, and but in case you're not seeing the screen, let me just say that it's, well, I'm going to ask the Assistant Executive Director to read it because it's a little blurry for me.
So the complaint intake address is complaintintake@post.ca.gov. And hopefully it's appearing on your screen as we broadcast this meeting. There's also a phone number associated with it and an email contact box. I believe in your case, the information you submitted was handled through a California Public Records Request Act, not through our complaint intake. So this would be the appropriate place for you to file that complaint.
Do you understand that there?
Yes, ma'am.
Okay, so
Thank you.
apparently it went to the wrong place, but it's very important that you called today. It's very important you gave us this information, and now it's very important that you put your complaint through the complaint intake. Okay?
Yes, thank you so much. Have a good one.
Thank you so much. Is there somebody else who'd like to speak?
Hello?
Yes, I can hear you. Please go ahead.
Hi, yes, my name is Crystal Rodriguez. I'm calling on behalf of, I'm a community member here in Barrio Logan. And I just want to say how outrageous it is that we still have those same officers patrolling the same streets where they committed murder. Even like they don't even, why are they still in the same street? Every day we encounter them and they harass our community. They're constantly stopping people and presuming things and assuming the worst of everybody instead of doing their job and actually going through the procedures that they have to, but they make comments. Those officers that come in the community are always targeting and harassing and disrespecting our community constantly. We don't even get the same humane treatment that other communities do. And it's why it's like we get generalized as one in this community, and I don't believe it's like ethical to have an officer here, to have an officer that committed murder down the street still patrolling these streets. How are we supposed to feel safe with somebody like that in our community? And
It is absolutely our mission to ensure that you feel safe. And we're absolutely going to be looking into this. And I very much appreciate your call. Was there something else you wanted to say? I didn't mean to interrupt you.
oh no, that's all I want to say. That was just my main concern because we have kids, we have community members that are always here and that are always, I feel we just get categorized in one label and we get treated like that, and I don't think it's ethical or appropriate for any officer to treat anybody like that, especially if they've
It's neither ethical nor appropriate. You're 100% right.
okay, thank you. And then I would want to have that be a priority to remove those officers from this community because people don't feel safe, and it's just many people in the community don't feel safe, and that's all I have to say.
Thank you. You've made that very clear, and we will absolutely be looking into this. I very much appreciate your call.
Thank you.
Thank you. Is there anyone else who would like to speak? There is
Hello?
anyone else that would
Hello,
like to-
can you hear me?
I can hear you. Thank you so much. Please go ahead.
Hello, can you hear me?
I can hear you too. Let's have one at a time.
Go ahead and go first, and I'll go after you. Thank you.
Okay.
Thank you,
It's
sir.
me.
Go ahead.
Oh, go ahead and go.
Okay. Darwin Fishman, he, him, his, Racial Justice Coalition of San Diego. And I'm also calling in for Chris Diamond. I did want to say that one of the reasons why you're getting so many calls about this and from San Diego is that we have serious problems, serious issues, the same as in other communities, with racial profiling. And our young Black and brown community, young men of color being targeted by police and harassment. And if you have young men that keep getting targeted for traffic stops and basically nuisance with the police, it's not unusual. It's not going to be surprising that folks are going to snap and it's going to be enough is enough. The third stop, the fourth stop, the fifth stop, all of the work done on racial profiling, all the research that's been done here has shown that it's a disproportionate amount of people of color that are being pulled over, and they're the ones that are getting pulled over that end up with no citations or things like minor traffic violations. When you have that and then the situation escalates and the police officers are not properly trained or they have racial bias about these youth and think that they're here at war and they're more likely to use force and lethal force, it makes it horrible situation here. And we're calling in because we're looking for help. The tools, the resources available here, we've exhausted. They haven't brought justice for this family and the other families that have lost loved ones here. At least with the post commission and the process of decertifying officers, we have a way to address some of these officers that are the worst violators that we know keep doing this, keep harassing community members, and we have a way to get them out of this profession and other jobs, and also a way to get them out of our communities and doing this kind of horrific policing. And that's why we're calling in and we're doing this concerted effort. The communities, we know who these officers are. They're here on a regular basis. Many of them have been involved in one or multiple incidents, and this is something that's untenable. It's just going to keep getting worse, and this is why we're looking for avenues for posts to investigate and to hopefully intervene and help us with this kind of crisis that we have here in San Diego. Thank you.
What you've described does sound, in your words, both horrible and untenable, and we will be looking into it. Sir, thank you for your call. Now, there was another, I heard a female voice.
Yes,
Please
Can
go
you
ahead.
hear me?
I sure can. Go ahead.
Yes, what happened to Christopher Diarmond shocks the conscience. It is a gross violation of human rights, criminal law, and constitutional rights. Officers are creating orphans, widows, and widowers with impunity and without any criminal accountability. In every profession, weeds out the bad apples for the protection of society. And we're counting on you to please look into the serious misconduct and decertify these 4 officers. They pose a threat to every single person in the society. Thank you.
Thank you very much for calling, and that is exactly our goal. And I think it's fair for you to count on us, and we'll follow through. Again, thank you for your call. Is there anyone else?
And decertify these 4 officers. They pose a threat to every.
Okay, I think that perhaps the mute button was off. Okay, it doesn't appear there is anyone else, but there may be someone, so let me be silent. And if there is someone on the line, please speak up. Yeah, I think that perhaps.
This is Mr. DeArmond again.
Yes, sir, go ahead. Okay.
I would ask you to carefully review all the videos that are available. Ironically, they're available on the San Diego Police website. If you notice, and I know I'm not supposed to talk about this, but at the end of the execution of my son, they exchanged fist bumps, much like they just won a football game. I would ask you to carefully review videos that are available. Ironically, they're available on the San Diego Police website. If you notice, and I know I'm not supposed to talk about this,
Sir,
but at the
are
end
you
of
still on the line?
execution of my
I'm
son,
hearing
they
Okay.
fist bump.
As a mother of 4 sons, I can't imagine the torment you're going through, but I can tell you as chair of this organization, we absolutely will look into it and also go in search of those videos you just talked about.
I really greatly appreciate your efforts. Thank you so much.
Absolutely, sir. Thank you for calling.
Yes.
Is there anyone else on the line? Okay, I think what we're going to do is just go through the approval of the minutes and then take a break. So are there any questions or comments from the board about the approval of the July 16th, 17th minutes, transcripts? Okay. If the board concurs, the appropriate action would be a motion to approve the minutes transcript from the July 16th, 17th, 2025 meeting. Is there such a motion?
Move to approve the minutes.
And a second?
I second.
Thank you. Any opposed? Any abstentions? Thank you. So we will go ahead and that motion is approved, and we'll take a break and come back at 11 o'clock for the new business. Thank you, everyone. Okay, we're going to start up. If I can get everybody to please take their seats.
That's your thing.
Thank you so much. I see that all the board members are in their seats and we'll proceed. We're now on to new business. We now move to the next items on the agenda. We have I'm sorry. I'm reading the wrong part of the script. Stand by. Okay. We're going to handle the cases possibly right after lunch, depending upon how long there is a discussion of the data. So we'll proceed with the discussion of the data, proceed with any questions you might have. If there's time, we'll begin the Kim case before we break for lunch, and if not, we'll proceed. I'll break for lunch from 12 to 12:30, and that should be a sufficient amount of time. So, Ms. Del Manayo will invite the bureau chief to come up, and now the report on data and for serious misconduct reporting, investigations, and disciplinary actions.
Thank you so much.
Thank you.
Good morning, Chair. Thank you, Madam Chair. We're going to go over some of the data that we presented in July to the board. We've got some updated numbers. One thing I'd like to add before I turn it over to Bureau Chief Christine Ford and Bureau Chief Sarah Wallace to review the data with you is we have made a concerted effort to go through and audit all 600 plus agencies that are required to report to POST and audit their serious misconduct reporting efforts. And we are in the process of actually today, tomorrow, sending correspondence to agencies that we've not received reports from. And those agencies that the reports we have received do not appear to be proportionate to the number of peace officers that are employed with that agency. The effort will help us reconcile our data against the data that the agency head believes is representative of their particular agency. Keep in mind that zero reporting agencies, some of those involve, as we've mentioned in the past, agencies that have very few peace officers, maybe 5 or 6, DA investigators, Harbor Patrol Police, Airport Police, some of the state agencies that employ peace officer classifications, where the scope of responsibility is not patrolling the communities. Thereby, there may not be the types of serious misconduct complaints that would be typical of an average law enforcement agency. However, when we come back to the board in February, we will be able to provide you the exact numbers and responses from those agencies. With that, I'm going to turn it over to Bureau Chief Sarah Wallace and
Let me
Bureau
just
Chief.
interrupt for a second. Are there any questions about what Ms. Del Nayo said just now? Wonderful. Please proceed.
Thank you. Okay. So I'm now going to turn it over to Bureau Chief Sarah Wallace, Intake Disposition Bureau, and Bureau Chief Christine Ford, who oversees our Southern Bureau. For those of you who might remember, we've consolidated LA County and Southern Bureau. It's the largest bureau we have in the professional conduct region, and Christine has taken on a pretty lofty assignment in overseeing a collective thousands of reports that are sitting in Southern California.
Thank you. Thank you. Good morning, Madam Chair and board members. I know that you were provided the certification stats prior to today's meeting, so I'm not going to cover those unless you have a specific question. So those are slides 1 through 12. So we'll go ahead and start with the Accountability Division. Thank you.
Excuse me, Christine. What I'm going to ask the board, because you have all had an opportunity to look at it, you're going to hear the presentation now. It's probably better to ask your questions as you see something that concerns you. So I will stop the speakers, and if you just raise your hand, I'll call on you, and then you can address your questions. Thank you so much. Please proceed.
Thank you. So as our Assistant Executive Director already mentioned, we have 611 agencies that must report to POST. 24% have zero reporting or actually have less than, have not reported. Half of those are agencies which have 10 or less full-time peace officers. She did cover the letters. What I plan to do with these slides is just give you a brief bullet points. And if you have questions, we can go into deeper on each slide. But was already mentioned that those letters will go out this week.
Question. Question. I didn't notice. Please, thank you so much. Yes.
What's the previous slide? So you mentioned that that the agencies, and that was, I know we had mentioned it previously in one of the questions, they're supposed to report to you misconduct reports. Am I correct?
Yes,
But
within
it's
10
not
days.
mandatory. And that based on your slide, you said that you're seeing that maybe agencies that have less than 10 officers, is the number correct? That are not reporting, right?
No, it just indicates that the 24% that we have 0 reports from, half of those basically have 10 or less officers. So the probability or possibility that there is no allegations of serious misconduct is a valid reason why they have not reported any cases.
So I guess I'm not, so from agencies from 10 to let's say 25 or 50 officers, where would I see that as far as the breakdown?
It's within the first paragraph, draft that, or graph that shows 0 to 49. 147 currently have not reported to post.
Okay, and they're not, this is not a mandatory thing they have to do. It's
If they get a complaint, charge, or allegation of serious misconduct, yes, it is a mandated report.
It is a mandated
Yes.
report. Okay, I thought the last time we didn't say it. Okay, thank you.
Thank you. Question, Dr. Weiser?
Well, just on that point, I think we began a discussion of this last time, and it might be worth bringing up again, which is just that there could be the possibility that there would be a mandate to even report 0 incidents. So that there would be an annual or even quarterly reporting requirement, whether or not there are misconduct cases.
Thank you, Dr. Glazer. That's what I was going to speak to with Regina's question. Yes, so with the letters that are being sent out, there is a mandatory acknowledgement by the agency head or the agency designee of either the 0 reporting or the less than what we would maybe deem proportionate reporting. So they will be required to respond to us by a certain date and verify the information. Teams are moving forward. It would probably require a regulatory action so that there's some force and effect of that requirement to require an annual reporting and reconciliation of, even if there are 0 reports, that someone's signing their name to that fact and recognizes that it is a mandate. Thank you.
One last question.
Yes. Lieutenant Meyer.
She was first.
Okay.
Oh, please go ahead, by all means.
I kind of forgot my question, but no, so in this reporting, and I have to go back, I'm sorry. In part of this reporting, some of the things I'm kind of questionable to me when we looked at the levels of serious misconduct versus the agency's policy and what is deemed as truly what we consider misconduct. In some of the cases that we've seen, we've seen where agencies, based on their policies, have, and I don't like to use the word undermine, have taken a different position to challenge the authority of what post. Going to tell me that. Kind of somewhat have created different policies that circumvent what post policies is, and we're going to be seeing that, in some of the cases where post is clear in. So what I think is clear in their description of what misconduct is, but we're finding out the agencies are not clear. They're kind of making up their policies as they go along. So in that, it's kind of concerning to me because it's like, when did the two meet? Other than if a person does not file to post directly what the agency said as what they deem as not being misconduct, it just, it goes away. And that's what the community is calling for, is when do the two make sure that they're both on the same level playing field.
Okay,
And
thank you. I understand your question.
so
and
you understand what I'm saying.
I'll ask.
Thank you.
No, go ahead. You want to respond, please?
So we've discussed this as well as what is post audit authority within the penal code, and post does have broad audit authority within the penal code. The challenge is the agency determines complaints, charges, and allegations that fall within the 9 acts of serious misconduct, which is what you're speaking to. And that is what is mandatorily reported to post, as if it's one of the 9 acts. And if the conduct falls outside that, arguably it would not be within post jurisdiction, the agency would not report it. So we've been in discussions about, is there an opportunity for post to specify by regulation that it has this broad audit authority to go in and look at IA files and look at complaints with agencies who may or may not have been reporting the volume of serious misconduct, to determine whether or not they do understand which of those complaints, charges, and allegations and completed investigations need to be filed with post. Again, that requires manpower. So that would be a tremendous lift. What we're trying to balance right now is we have 40,000 allegations of serious misconduct that we're working through, where agencies have reported, and some of those are significant and serious. And so would we be able to even be diligent if we tried to take on this audit authority right now when we're trying to manage the volume of complaints, charges, and allegations that we see? So it really is a resource issue at this point. I think the first step is starting with these inquiries and getting someone to acknowledge that they understand the requirement. The penal code requires that they submit this information to post. We have on record that they may not have submitted anything, or what they've submitted does not look proportionate. And I think that's a first step in the direction of trying to get on record. And then I think we need to move from there.
Captain Laura?
So it's to Jack's earlier comment that the zero reporting is not without precedent. I'm thinking of the use of kinetic energy weapons during a protest. Even if there is a zero utilization, that the month by month, the agencies have to report that out. So it might require, like you said, some legislative action, but that sort of reporting, zero reporting, is not without precedent.
Thank you. Sheriff Doyle?
I'm not naive to think that there may be some agencies that are circumventing SB2, but I remember, Anne Marie, that initially there was a great deal of over-reporting. Up to like 1/3 of the cases didn't fall within the authority of post to investigate. Correct?
Yes. For Doyle, to your point, it's that greater than 1/3. I would say there's a vast majority of probably anywhere between 78, 82, 83%, maybe a little higher, that are not sustained, unfounded, or exonerated complaints, charges, and allegations that end up, the agencies reviewed them. And I think this is where we keep going back to the fact that the volume of those cases that would not move forward because they don't meet the threshold of serious misconduct is substantial. That's the volume that I would say. Again, if you look at 40,000, complaints or allegations, you're talking about somewhere upwards of 83% of those are cases that would not move forward because there was no serious misconduct. There is some what we might consider over proportionate reporting coming from some of the larger agencies. And that stems from the complaints that come in that are perhaps bias complaints or complaints on abuse of power, that are just complaints of individuals being pulled over, individuals being approached by police officers. And there's a complaint made that the individual was, the peace officer encountered the individual because of their race, sexual orientation, or some other factor outside of an act that violates the law. Those typically end up as being, there was no nexus there for us to be able to move forward. So some of the larger agencies in Southern California, you might consider it in proportion to the number of peace officers they have, over reporting, but they're actually doing their job. They're reporting every complaint, charge, and allegation that looks like it meets biased conduct. or abuse of power or something of that nature. So I think we have both ends of this, and then we're trying to keep a closer eye on the cases that, for example, that are being reported prior to there being an agency finding. And then looking at that agency finding, what proportion of those cases do we see amount to serious misconduct? Because that's the agency being forthcoming about a complaint, charge, or allegation before they've completed their investigation, which is part of Senate Bill 2. And what does that investigation yield? And then what percentage of those cases do we really see meeting that threshold of serious misconduct? Because that really shows the agency is being forthcoming about their reporting to post. And I think that would be a good statistic to share.
Dr. Glazer?
I may just for the sake of clarity, I want to emphasize that we want to be careful with the use of over-reporting. If they're in compliance with the law and they're reporting things that are not sustained, that's not over-reporting. It's
Correct.
just so. And I wanted to see clarity that we don't have a requirement that there be a sustained finding at the agency level in order for us to find clear and convincing evidence of serious misconduct.
Thank you. Yes.
And I think that's clear by the two cases we have today as well. So yes. Anything else from the board members? Okay, thank you. Christine, please.
Okay, this slide shows the total processed reports. As you can see, we've stayed pretty consistent with 2,500 reports per quarter. This next slide will show you in the gold reports with final disposition. I think the key point to take away from this slide is that much of what we're getting are open investigations. Until we receive the final disposition from the agency, the majority of cases that we are receiving right now are going to be open with the agency. The gold just depicts where an agency actually sends an original report with a final disposition included with it.
Christine, just a thought there. Are we through with the retroactive cases now?
I would say the majority of retroactive cases are complete.
So what's interesting to me is that we're seeing a consistent number in terms of cases, even though we've already gone through the retroactive cases.
Correct. The majority of cases we are getting right now are current
Thank
cases.
you. Please go on.
Morning, Chair, members of the board. My name is Sarah Wallace. I'm the Intake and Disposition Bureau Chief. I'm going to be going over some of the public complaint statistics, and these are similar to what we shared back in July. As you can see, we continue to see an uptick in the number of public complaints that are being received by post. Currently, we have over 2,500 officers who have received complaints. I do not believe the pool of approximately 2,700 complainants. I think it may be lower than that, but there are 1,600 unique officers that have been identified. Based on the discussions at the last meeting, we are working with our computer services division to see how we can extract additional data to determine how many complaints have come in prior to the agency reporting versus the agency reporting prior to receiving the public complaint, and going into a deeper dive as to whether or not those come in with final disposition or if they are acknowledging that they've received it and they are moving with an open investigation, and should be able to provide additional details at the next meeting, as well as timeframes. Next slide. Based on the last meeting, we inserted a slide to provide an overview of the post-public complaint process for readily available information in case there's any questions. But this shows the workflow. When post receives the public complaint from a member of the public, we acknowledge that complaint, forward the complaint onto the agency, receive the response to the agency, and we conduct our own review of the incident. Next slide. We continue to have complaints grow. Here is another snapshot. You'll see at the bottom the 10 complaints that have resulted in certification action. That number has not increased since the last meeting, and those were all resulting in the agency having reported prior to receiving the public complaint in those cases. This also provides a snapshot of complaints received against chiefs and sheriffs. Again, we do a specialized process when we receive complaints against chiefs or sheriffs or any of our Mark 43 reporters, where we consult with the Professional Conduct Bureau chief, determine whether or not it's appropriate to send to the agency or if the bureau chief wants to handle it in an alternate fashion before notifying the agency.
I have a question. What period does this graph reflect? The entire?
This is the totality, so from January 2023 to current,
All right, thank you.
or well, I'm sorry, till middle of September of this year.
Okay, as you can see, the division has received over 35,000 report updates. Now, this is in addition to what we received as the original reports, which are 39,000. So as you can see, we are taking in a significant amount of agency supplements. The key on this slide is to give you an idea that at the time an agency submits a case to post, and when they actually send us a final finding, it averages at about 8 months from that time.
I would just note that the fact that we are seeing an increase in public complaints is a good thing in terms of what it is that Post wants to let the community know that we're truly here to hear this information. So any concerns about law enforcement agencies filtering what comes to us through them, I think that's the way we can clearly see that that's not what's happening at the moment, but rather what we're seeing is an increase in the public knowing that they can assess Post and make these complaints. Did you want to comment on that, Christine? Either one of you?
Vera might want to comment.
We are noticing an increase in the intake of public complaints, and it seems to be there advocates that have been coming to Post meetings we've been doing outreach with, and I believe that that's also contributing to furthering the transparency of what is available for public complaint process at Post.
Excellent. Thank you. Please go on.
Okay, this will show that we've, over those cases, it's about 45,000 serious misconduct allegations, which are unique to about 21,000 officers. To give you some context, we have over 80,000 peace officers in the state. Our top three, excessive use of force, demonstrating bias, and abuse of power, are our top three that has remained the top three since the inception of SB2. As you all know, we prioritize our cases. This gives you an idea for each allegation. The next two slides will show, or the two slides will show you the 9 allegations.
Sorry, on the previous slide, are those three the ones that are also retroactive? So I'm wondering if part of this,
Yes, it's
this pattern
everything.
is because those are included in a longer period of time.
This is from the inception, yes.
I have a question also, Johnson.
Please.
I can remember it was like 32,000 when we began to sit in the rooms, and we understood that it was like maybe 12 or 15,000 that was retro. And I thought I heard earlier that basically that 12 or 15,000 that was retro has actually all been completed. So I guess my question is, that seemed pretty quick. It was just a determination looking at the complaint and then just writing it off as resolved?
Well, my prior comment was the majority have gotten through the bulk of our retro. We do still have several thousand retro cases that we are looking at. Most of those are going to be our priority 3 cases. So I do have a slide that's after that we can talk a little bit about the process of what we're still doing with those priority 3s and the closures of those.
I was wondering, being that they're going so quick, I'm sure some of the community members are probably complaining about that, but we have seen an uptick in complaints being filed with the commission or Post, correct?
Yes, we are seeing an uptick of complaints filed via the public complaint process. I think I think this might help address the question, but with the retroactive reporting, there were a certain portion that were non-actionable cases, and that was written into the statute. So I think that might also help clarify why those were closed, because they were deemed non-actionable. There were only 3 acts that we would have been able to take action on during that point in time. Up until any allegation that happened or the findings of the agency until January 1st of 2022. There were only 3 acts, and it was sexual misconduct, excessive use of force that resulted in bodily harm or death, and dishonesty. So that was a smaller portion, and those may have continued to be investigated. However, anything that fell on the other 6 categories would have been closed as non-actionable. And so I think that's why you're going to see those particular cases closed.
Does that respond?
Yes.
Thank you. Okay, please go on.
As mentioned before, we do prioritize our cases. As you can see on the blue graph, much of it is priority 3s. I do want to make a comment that the prior slide we had talked about, our top 3 were basically use of force, bias, and abuse of power. But as you go into a little bit of the numbers, our priority 1s, our top 3 is dishonesty, accept, violate, and excessive use of force. So it varies a little bit on allegations as you change the priority on the case. Second slide is just going to show the remainder of the allegations. Next slide. 80% of our ITS public complaints and priority cases, that's priority 1 through 4, are closed. I'd like to concentrate a little bit on the right-hand side of that bar graph. You can see that there's a bulk of open cases. The ones that are depicted with 2996 as the number are unassigned. The majority of all those cases are priority 3s. So they're unassigned on our system internally, but our staff does grab from that pool and assign themselves that case, and then they work it. So that's why there appears to be a lot of unassigned open cases, but they really are being worked constantly. Okay, so this chart will show you kind of what we talked about previously, the abbreviated review of our priority 3 cases. As you can see, there was a big spike in it in Q1. We've leveled out a little bit in Q3. What I do want to mention is that our staff still reviews all the documents that the agency submits. They do verify that the finding matches what is in the content of the report that they're sending us. And then they do their closure. So it's not a quick review. They are spending time reviewing all of those documents and confirming that the agency's findings match what is contained in the report.
Yeah, is that graph wrong? I mean, it indicates that the abbreviated review period started in Q2, but the big increase in closures started in Q1. Possible the abbreviated review began in Q1?
Yes, it did. It started in Q1.
Okay.
Yeah.
Thank you.
Thank you.
Okay, this next slide is going to show that for all the closed cases, we're well within that 3-year statutory timeframe. Again, once we get a case and we review it, the average of post-closure is running at about 8.5 months. Now, I'd just like to make a comment. I know that in several other board and commission meetings, there's been discussion on the length of time that Post has had the case and why did it take so long. Many times when an incident occurs, the agency will send us the report. It'll be an open investigation. So what we talked about earlier in a slide, it takes on average 8 months for the agency to complete that investigation and send it to us. We investigate it. We average about 8.5. So that's what your time lapse is there. Many times there is a longer duration because one, it could be that we choose to wait for the results of arbitration or a board hearing, or we may use a subject matter expert on a case. A lot of times agencies will have a case where they have a criminal component to it and they run that IA parallel to the criminal complaint, but they'll complete their administrative investigation and send it to us. So there are some reasons why there could be a duration in time.
Let me ask, how often does it happen that you go back to the agency, ask for a follow-up report, and there is a delay in terms of getting that report to you?
I would say that it's frequent. for the amount of work that we have as much as the agencies have. It's just it's a matter of getting to the task and being able to complete the task and send it to post.
And obviously you're out of control of how long it takes the department to get that to you or the agency to get that to you.
Correct.
Okay, just make the board aware of that.
Johnson? I guess, we had quite a few public complaints or speakers today. And so in regards to Christopher DeArmo, the father said he had filed a complaint, I guess, in July, and hadn't heard anything yet. Can we get a reference of what it takes, I guess, for the family member to actually receive some information concerning the complaint they filed?
So post intake acknowledges receipt of the public complaint immediately. Typically, we're processing within 1 business day. And so we would send an email if that's how the complaint was received, or via a mail a letter via the mail. We then immediately refer it to the agency, and then typically the agency responds with an acknowledgement, but then it can take up to a year in some cases to get the final disposition. In general terms, we, as intake and disposition in our public complaint case management, do frequent follow-ups with the agency. And if we're not receiving feedback or response to the allegations, then we escalate it to our bureau chiefs, who then reach out to the reporters and the chiefs or the sheriffs. So our goal is to get the information as soon as possible, and then it goes through the review process with the Professional Conduct Bureau. So there isn't a specific time frame in which the complainant will receive information, but if there's decertification, it'll become available at the meeting. But they are acknowledged, and we do provide updates when possible. And if they contact us, we will put them in contact with a law enforcement consultant to give them information that is available.
So the complaint is acknowledged
Yes, almost immediately.
almost immediately.
Mhm.
So his complaint was filed. He received notice that it been received.
As soon as we receive the complaint, we open the complaint and send an acknowledgement letter to the complainant with a notification of what the complaint number is, whether or not that complaint has been referred to the agency, or if it's under review by post. In all circumstances, we are going to have to collect information from the agency so that the complainant is notified that the agency is aware that they've been notified, and then we immediately send a notification to the agency. There is notification sent via our complaint case management system, Mark 43, and we send an email follow-up as well. And then we continue to work the case until we receive follow-up information from the
I'm
agency.
not sure if I heard it correct. I thought he said he had never received any response.
I believe what he said was, he may have said that, but I think what he meant was a response that was more than "we got your information." I think he was looking to know here, maybe let's use the word reaction. But all he got so far was "we received your complaint." I think your question, and please correct me if I'm wrong, is in general, how long does it take from the time someone files a complaint with Post for them to get a substantive response? Want to respond to that?
Unfortunately, it depends on the agency and the time frame in which we get the information, if they're aware of the allegation, if they've already conducted an investigation, and then how long it takes our professional conduct bureaus to also review the case and go through the review process.
Can you give us a range? Is it somewhere between 8 months and 2 years or something, so that Mr. Johnson can feel that his questions are answered?
And there's some cases where the agency responds right away, and those are closed. We're going to be going over some closure statistics, and I'm hopeful that the statistical program that we're working on is also going to help tell that story at a future meeting. I can't speak to specifics, but I would say within 6 months to 8 months, they're typically referred over to the Professional Conduct Bureau, meaning that we've received the response from the agency, they've finished their investigation, and now it can be looked at by our Professional Conduct Bureaus.
And just to follow up, because I know it's going to come up, from the time it comes, from reports all come to you to the time you form an opinion, about how long is that?
Again, it depends, and I'm hoping that the statistics we pull together will tell the story in a more concrete terms. But I would say it takes our investigations, depending if it's non-serious misconduct, typically we're able to close those right away. If there is allegations of serious misconduct and we're waiting on information from the agency and the Professional Conduct Bureau, I could say it's anywhere from 6 months to a year until you have that final determination.
Does that answer your question, Mr. Johnson? Thank you. Thank you. Please
Chair, may I point something out?
Please.
So we did provide that statistic, generally. The average time frame in which an open agency misconduct report receives an agency finding is 8 months. So that's in your statistics, and Christine covered that a little earlier. So that's the point, that they submit an initial AMR, which is an agency misconduct report, without a final disposition, meaning they haven't completed the investigation, or maybe they have, but they haven't sent us that final investigation. So it's on average 8 months. So if you take that into consideration, and then Post then has to do its analysis, any gap investigation that needs to be done, interviewing the officer, interviewing witnesses, procuring additional documentation, which oftentimes there is some of that because they don't completely align in terms of the agency findings, goes back to Ms. Crawford's remarks earlier about policy violations versus serious misconduct. So if you take that all into consideration, it can be over a year before we have a final package. There are stats that Christine's going to cover here in a few minutes that talk about the average time frame to close a case when we have a final disposition. Yeah.
Thank you.
You're welcome.
Please continue.
Here. Next slide. Okay. Okay, so for our closure cases, approximately 95% of our closures have the no further action closure status. As you can see, the breakdown for voluntary surrenders, revocations, and ineligibles make up 1.4%. From the no further action, the reasons of that are broken down here on this next slide: not serious misconduct, not actionable, not clear and convincing, and deceased.
Yes, Ms. Crawford.
Also, Johnson, my thing, like when we say not serious misconduct, it's a high number. When we say that, not serious misconduct, I guess that was my question between what we think is not misconduct and what the public think is misconduct. And so there's some clarity I feel that needs to be defined.
Or how we would say not serious misconduct, under most of those circumstances, those are gonna be our priority 3 cases where the agency has had a not sustained, exonerated, or unfounded, does not meet any of the definitions of the 9.
And so the bigger concern is there probably is a high number of not serious misconduct, and it's coming from the community that feels that when you see an officer that you can tell by mannerism is overzealous in their conduct, I mean, it's obvious and it's subjective, as to what we may feel as a community, and I'm speaking for my community, and what Post may see. So I guess how would you clarify that, define it, to make the person feel good about that decision being made?
Sure, I think there are a lot of circumstances where you had mentioned earlier about policy violations. The agency reports that and will implement their discipline in regards to that. We, on the other hand, are a licensing part of it, where if it doesn't meet the criteria, that's not a case that we would be able to move forward with. So I think that to answer your question is it could be a policy violation, but not necessarily meet the serious misconduct allegations that we deal with at Post. That doesn't necessarily mean that the officer isn't disciplined by their own agency on reporting it to their agency for discipline.
And so that was me listening to this family, the transparency that people felt that SB2 was going to give them as a community, that each one of these actions has to be somewhere tangible and accountable in a sense. We know that if a behavior and a pattern continues, even if it's just a policy violation, it can lead to deadly actions. And so that is my concern of why I asked about what is the clarification of misconduct, because we've seen in incidents where probably the officer is trainable. Probably we could have stopped that, but how do we make this preventable? And that was just my statement, comment, not so much a question.
Thank you.
Thank you.
Dr. Glazer?
Just have a question about that graph that was just up, which is there are two cases where this board recommended revocation and the post commission countervailed our recommendation, and the result was no further action. And I'm wondering if those cases appear in these graphs. It's a previous one, but yeah, exactly. Or if we need to add a column to that graph.
They would not appear in this slide. So yes, we can add that to that.
It's you're going to see it in a future slide.
Yes, Johnson too. I know, as I was listening to the community speak, I think the biggest complaint was they didn't have any information. And so I know when we sent out a letter to an officer that his license is going to be pulled, they have 30 days to respond. So maybe some kind of way we can work in a plan on how, if a complaint is filed, 60 days or less, 45 days, there's a if a complaint is filed, immediately the complainant is going to receive a notice. But when 6 months pass or 3 months pass, they're wondering what's going on. So maybe we could work in some kind of 45-day, 90-day period where you respond, or the complainant is aware that this could take up to a year to 2 years. And periodically, of course, resources and time and all that, but I think it would probably ease the community concern that their complaint is not being heard or investigated if they knew that something was happening in that timeline of a 2-year wait.
Thank you for the comment. I think that's a great suggestion.
Okay, please go on. I agree. I think it's a great suggestion.
Public comment, this is yours.
This is another slide that's similar to what was shared in July. Closure trends among public complaints. We continue to see the majority of the complaints closing as not serious misconduct, and we do continue to receive complaints that are not within the jurisdiction of post, meaning they are indicating complaining about a person who's not defined within the penal code, that we are able to take action. I'm happy to answer any questions.
Dr. Glazer?
I have a question about this. The three instances there where from a public complaint there was a revocation. Do we happen to know if that corresponded with any action that was happening at the agency level simultaneously, or was the public complaint what triggered that? I'm just trying to get a sense of whether public complaints are adding value in terms of additional revocations that would not have occurred but for the public complaint process.
Those are all within the 10 cases that were shared previously that we had previously received indication from the agency.
I think it speaks to Dr. Glazer, if I may, Madam Chair.
Please.
Okay. Your question earlier about, or the data that Ms. Wallace indicated that we would be providing in the future, which is of the public complaints that are coming in, how many of those have an AMR that's already with post? How many of those, the initiation of the public complaint itself is the first indication of serious misconduct? What of those public complaints result in disciplinary action? How long did it take us to get the final disposition from the agency? So that's all data that I think is very relevant to, are we taking action, or is the impetus of that action really starting from the public as opposed to being generated from the agency? I think that's what you're getting to, I hope, and then we can meet that need by providing that data. Okay.
Thank you. Please continue.
Okay, this just gives the number of disciplinary actions taken by Post, which shows it's above average compared to other California regulatory licensing agencies. I know that the board had asked us to try to compare our action rates to other comparable peace officer training commissions, and unfortunately, we were unable to find something that was comparable to what we do and our actions. So I'm not able to compare that with other commissions at this time.
Still, those numbers are very compelling.
Yes.
Any other comments, questions from the board? Okay, please go on.
Our top allegations resulting in action, just of note, the top are acts that violate the law, dishonesty, and sexual assault. So it differs a little bit from what we talked about earlier, which was the bulk of allegations that we're getting from agencies. The top three were different. These top three indicate basically when we've taken action on an officer certification. So different allegations. Arrests and indictments for Government Code 1029 are really the highest basis for our issued immediate temporary suspensions. I don't know if you have any questions on this chart, but this basically shows that out of the bulk of the ITSs that we are issuing, it's based on an arrest and or an indictment. Over half of our subject officers who have received a notice of intent to revoke letter, we've sent out 60. As you can see, 37 were defaults, which basically meant that the officer did not respond or appeal. 22 notices have resulted in appeals. You've heard thus far 20, and you'll hear the remaining 2 today. Almost half of the cases received a notice of intent letter. Post captured additional causes and or amended the allegations that were originally submitted. There could be various reasons why we would either add or take away an allegation that which was originally submitted by the agency. A lot of it could be revolving around a criminal case where the DA does not file. Or in turn, even if a DA does not file, we still could look at that case because we would have a clear and convincing evidentiary standard versus the DA's status there. So, and this is a slide that the board and commission in comparison and what you as a board have recommended versus what the commission has recommended. There is one case that you'll see that you've heard 20 cases. The commission has not made a decision on one, which is the case that they heard last session. They have not made a decision on that case yet.
So on the, I guess since the inception, right, has any officer appealed the commission decision to the administrative judge? What's the percent on that? And then what is the status of those?
So we probably have roughly 10 appeals right now before the ALJ that are in various proceedings. We've had one case, albeit a cancellation case, that has gone before the administrative law judge, and we will have a proposed decision before the commission probably in early spring, if not March, I would think. Those cases, depending on the calendaring, so once they go to the once they go for an ALJ hearing, they're in the Office of Administrative Hearings. It can take anywhere from 4 to 6 months to get them calendared. So there are several that have been calendared. I think we have another one in October if it's not been postponed at this point. And so we should have this next year, we should have the results of those cases that have gone all the way through the due process, the administrative proceeding process. Yes.
So thus far, none have.
Just one cancellation case. Yes.
They've either explain what you mean by cancellation.
Sure. So there's different actions. There's a denial. So if someone comes to post and is attempting to get a certification and for some reason we believe that either they don't meet the minimum qualifications to be a peace officer, or there's something in the background that constitutes serious misconduct, and we've done a thorough investigation, we can deny issuing a cancellation or issuing a certification. That they can appeal, and that could go before an administrative law judge as a statement of issues. There's also where someone has secured a certification by fraud or misrepresentation or deceit, and thereby post can take an action to cancel that certification, and there's an appeal process for that. And this particular case was as such. There was securing a peace officer certification. The allegations are by fraud, misrepresentation, or failure to be honest during the course of a background. And then that goes before a judge. The judge makes the decision as to whether or not that certification should be, makes a proposed decision to the commission about whether or not that certification should be canceled. So that's more on the administrative licensing side. We're on the disciplinary end where we're filing an accusation to revoke a certification, as you know, and then that gets set for a hearing. The hearing occurs typically between 4 and 6 months. There again, opposing counsel oftentimes requests continuances for various reasons. Those are entertained as well. So sometimes that process can be delayed.
So the cancellation cases have nothing to do with us, this board. Yes, Dr. Glazer?
Yeah, a question. It looks like from one of these slides, there are about 300 immediate temporary suspensions so far. And I'm trying to grapple with how that relates to there having been just 60 notices of revocation. So, because my impression had been that the ITSs are pretty severe, and I'm just wondering what's happening to the rest of them.
One of the major contributing factors, and then I think Christine and Sarah can weigh in as well, is that ITSs can be as a result of someone being indicted or arrested for charged with a felony. And so the criminal proceedings would happen first, and we're told, meaning so our administrative case would be on hold, but the officer certification is on hold as well. So that represents a good proportion of those ITSs as to why they haven't moved all the way forward for recertification.
Thank you. Please proceed.
I would just comment that a substantial proportion of those ITSs did result in 1029 revocations that would not come before the board. And so you'll see that count of the 1029 revocations include those that had started as an ITS. The ITS statistic that's shown, and I'm looking for the page, I believe it's a cumulative total of all ITSs issued, not a current status of how many ITSs we have at this point in time.
Thank you. Continue, please.
That concludes our presentation.
Okay. Questions, comments? And I appreciate how everybody jumped in when the issue arose. It'd be too difficult to go back. So all of you did that at some point. So any questions that you haven't asked?
I guess one for me then would be, I think it's been over 300 plus officers that have been decertified. Is that number somewhat close?
Yeah, it's in the slides. Go back, if we can go back and identify the slide, we'll put it up there so I can answer your question. Yes, so the slide on the number of disciplinary actions taken by post, that slide. Yes.
There's 643 disciplinary actions that have been imposed by post.
Oh, 631?
I think they're looking, he's looking for the decert number.
Yeah, the decert number.
How
actual
many people have lost their
decertification number.
certification?
Okay, so then of those, 129 have been deemed ineligible through the 1029 government code section. 115 have done the voluntary surrender. And then through decertification, there has been, there's an additional 98 that have been revoked through 1029s, 35 that have been revoked through default revocations, 3 that have had revocation stayed and then settlement terms imposed, and 2 that have been suspended.
So those were a lot of numbers. I think Mr. Johnson is asking for the total number altogether of all the deserts, whether they were default or whether we found there was a finding, whatever. And he said it was about 300. Just want to get the clarification there.
That's come close to 300, huh? If we total these total numbers up.
Yeah.
Yeah. So, I think that answers my question, yeah.
Thank you.
Yeah.
Anything else? Okay, so just to be clear, at 12 o'clock, we're going to take a half-hour break for lunch. We'll come back at 12:30, and when we come back at 12:30, we'll be discussing the Michael Kim case. So anything else on statistics for now? Oh, yeah. Okay, I also want to check to see if we have any public comment remotely on the certification statistics. I think at one point I saw that someone raised their hand remotely. So I'll be quiet, and if anyone would like to speak remotely, please do so. Okay, there was a question raised hand. That, sorry, this certification statistics. I have a shout out for Charles Lara. And
The other thing too, by the way, we need to keep track of now is opening for posts. I think there's an opening. I'll have to ask Uncle Bobby about that.
I'll volunteer.
He would like some help. Yeah, exactly. I'm sure
hearing a
he's-
bunch of voices. Hang on for 1 sec. I want to make sure we
No,
hear
this is
you.
good.
I see the
think it's
name
it's
David.
start,
Is David speaking?
And we'll see how this goes.
Hello, can you hear me?
Yes, is this David?
Yes, I'd like to add a few words, if I may.
Sure.
I find it
Anyone would like to speak?
outrageous that Captain Laura of the San Diego Police Department is part of this forum. It was under his direction that these case files were redacted. The redaction is immense. It's covering entire photographs, paragraphical, and factual information, doing much more than protecting the required PII. This indeed is a cover-up sanctioned by Captain Laura.
Thank you. Are there any other public comment?
Public comment?
Yes, is this?
Yes, I'd like to add a few words.
Again, I'm having difficulty trying to hear if there's a single voice. We've heard from David. Is there anybody else who would like to speak? Patricia, would you like to speak?
Yes, hi. I'd like to echo what my dad said about Captain Charles Lara.
Okay, let
He
me
was
tell you,
the
let me
one.
explain. I'm interrupting you, and I hate being rude, but this is public comment only as to the statistics. If you have any public comment related to the presentation you just saw, certification statistics, I'm open to hearing that at this time. If not, this is not the time.
Okay, so there will be no more non-agenda public comment, correct?
No, there's public comment solely as to the issue of.
Right, but is there going to be another non-agenda public comment?
No,
No.
thank you for.
Okay, well, those statistics, it's funny, if you look at them, it looks like most departments are not complying and doing what they should be doing. The rest, those graphs, those bars were very flat. So that means that they're not actively doing what they should be doing. And when you have captains that make the decision to redact records of your PRA requests like Charles Lara did, that makes all the sense, right? That's why the numbers don't add up. Just look at the numbers. The data's all there. They're not compliant. They're non-transparent. They're not doing what they're supposed to be doing. I have a legal right to be given the records that I requested, and yet Charles Lara made the decision to redact those records.
I'm going to stop.
Thank you. That's all I have to say.
Thank
Please
you.
look into my brother's case.
Thank you. Is there anyone else who'd like to make a public comment in this specific area? Okay, seeing none, we will now break for lunch and we'll be back at 12:30 with the beginning of the Michael Kim case. Okay. As soon as our assistant director is sitting down, we'll begin. You good? We now move to the next item on the agenda. We have two cases to hear today. We will only be reviewing the facts and evidence as presented by the division. This is not an evidentiary hearing. The rules of evidence do not apply here. Evidence is not formally admitted into the record. There is no need to make any objections, and objections will not be ruled upon. Under the Penal Code and applicable state regulations, this initial hearing will determine only if the matter proceeds forward for the commission review. And then, should the commission approve for a full evidentiary hearing before an administrative law judge to determine whether the allegations are true and justified discipline. For those commenting on each item at this early stage, the board must only consider the facts that the division, after investigation, believes can be proven at a later evidentiary hearing. For that reason, today, the board will entertain arguments as to whether or not those facts, as presented by the division, demonstrate clear and convincing evidence. In other words, a high probability that serious misconduct, as defined in Penal Code Section 13510.8 and Commission Regulation 1205, occurred. Actions by the board or the commission prior to a full evidentiary hearing amount to a final determination that an officer did in fact engage in misconduct or that revocation or suspension is ordered. That will be determined after the evidentiary hearing. At the conclusion of each law enforcement consultant's presentation, the board will have the opportunity to ask questions. Then public comment from the subject officer and/or their counsel will be taken, followed by members of the public. Further discussion by the board will be allowed if necessary. The board may go into closed session deliberations after each case or wait until all cases have been presented and adjourn into closed session to deliberate on all cases presented after reconvening into regular session. Votes will be taken on each case. At this time, I will now call upon law enforcement consultant Kevin Sherburne, Professional Conduct Central Bureau, and Carrie Woolley, attorney for Legal Affairs Bureau, to provide a report on post case 2410050, Michael Kim, who at the time of the events at issue in this case was and still is employed by the San Francisco Sheriff's Office.
Thank you, Madam Chair. Good afternoon, board members. My name is Kevin Sherburne. I'm a law enforcement consultant assigned, as the chair mentioned, to the Professional Conduct Central Bureau. I served as the investigator on this case involving Michael Kim. The case number is post 2410050. With me today is Carrie Woolley. She is legal counsel for Post. The clear and convincing evidence substantiated in this case that based upon his conviction for contempt of court, Mr. Kim was dishonest. On May 25th, 2018, Mr. Kim admitted to the federal court in San Francisco that he filed a declaration with the court that contained materially false statements, and he pled guilty to a violation of Title 18, United States Code, Section 401(1), a misdemeanor. Mr. Kim's dishonesty for serious misconduct purposes occurred when he lied to the court in the declaration and obstructed justice in the criminal prosecution of Andy Lee, and he lied to FBI agents who asked him about the declaration that he filed with the court. Under California Penal Code Section 13510.8 B1, dishonesty is defined as lies relating to two types of lies. First, there is dishonesty relating to the investigation or prosecution of a crime. Second, there is dishonesty relating to the investigation of peace officer misconduct. Mr. Kim's dishonesty is in violation of this statute because his false statements related to the criminal prosecution of Andy Lee, the criminal investigation of his own criminal activity, that is the submission of a false declaration to the court, and the investigation into his own peace officer misconduct. May we have the next slide, please? This presentation I've divided into 4 parts. So first, I'll talk about Mr. Kim's professional career as a peace officer. Then I'll talk about the evidence substantiating Mr. Kim's serious misconduct. I'll cover the reasonable grounds for revocation of Mr. Kim's certificates. And then I'd like to talk a little bit about some of the procedural aspects of this particular case. For purposes of the division's findings, the clear and convincing evidence standard means there is sufficient evidence to establish, quote, that there is a high probability that the charge is true, end quote, and the evidence need not establish a fact beyond a reasonable doubt. That said, in this case, we have evidence beyond a reasonable doubt of dishonesty based on Mr. Kim's conviction. Next slide, please. At this time, I'll give an overview of his professional career. Mr. Kim's professional career as a peace officer started in 1999 when he became a deputy with the San Francisco Sheriff's Office. He promoted to sergeant on February 12, 2005, and was a sergeant at the time of the serious misconduct. Mr. Kim resigned from the Sheriff's Office on February 13, 2016. At that time, Mr. Kim held basic, intermediate, and advanced certificates issued by post. In April 2021, Mr. Kim completed a requalification basic course and reapplied to the Sheriff's Office in May of 2021. The application expired, and in June 2023, Mr. Kim reinitiated the application process. He completed a second requalification basic course in August 2024. During Mr. Kim's background investigation, he completed questionnaires in which he made admissions that he committed perjury by submitting a false statement to a court and made false statements to FBI agents. Mr. Kim also underwent a psychological evaluation as required by post regulations. A key component of the psychological evaluation is the examination of what are known as dimensions that cover topics like integrity and decision-making or judgment. Under this process, a department psychologist conducted an evaluation. If that psychologist determined an applicant not to be suitable, the applicant had a right to appeal and hire his or her own psychologist. In Mr. Kim's case, the department psychologist deemed him, quote, not suitable, end quote. He appealed and hired Dr. Ryan Dunnigan to evaluate him. Dr. Dunnigan performed an evaluation on November 1, 2023, and deemed Mr. Kim not suitable for the position of peace officer. In my investigation, the evidence showed that an applicant's own psychologist very rarely failed the applicant. As a result of Dr. Dunnigan's determination that Mr. Kim was not suitable, the Sheriff's Office sent Mr. Kim an email on November 30, 2023, stating that it discontinued his application. In other words, it, quote, elected not to proceed with your application, end quote. While on one hand, the background process did not set forth another appeal for applicants who failed the evaluation by their own psychologist, on the other hand, personnel at the Sheriff's Office stated there was no prohibition on an appeal. However, it occurred in February of 2024, Mr. Kim did appeal Dr. Dunnigan's determination that he was not suitable for a peace officer position. And in this appeal, Mr. Kim submitted a letter of recommendation from Sheriff Paul Miyamoto. Dr. Dunnigan stated it's very rare he receives letters of recommendation from chiefs or sheriffs. As such, the letter carried, quote, considerable weight, end quote, because he said, quote, it leaned into his lane in the road, end quote, and Dr. Dunnigan deemed him suitable. But for the letter was the sine qua non of Dr. Dunnigan's suitability finding. Dr. Dunnigan likely would have again deemed Mr. Kim not suitable for employment as a peace officer based upon those dimensions I mentioned earlier. Counsel for Mr. Kim has submitted a public comment in which she states that investigators, quote, immediately seemed suspicious of the letter. Given Mr. Kim's lies, for which he was convicted, our suspicions were legitimately founded, and the division's investigations followed up in a thorough and objective manner to determine whether Mr. Kim himself authored that letter. The letter also had probative value whether there was abuse of power in the hiring process of Mr. Kim. After a third psychologist reviewed the previous psychological evaluations, the background investigation unit at the Sheriff's Office submitted the background investigation file up the chain of command. Counsel for Mr. Kim stated in her written submission that it is rare that anyone would be able to return to a sworn position after an incident of this nature. I would like to point out, and as noted in the investigative summary and findings, 3 of the 4 voting members of the Command Staff Hiring Committee voted to reject hiring Mr. Kim. Further, Dr. Dunnigan focused on the dimensions of ethics and judgment in his initial finding of non-suitability. On December 21, 2024, the department rehired Mr. Kim as a deputy. Now I'll go over the evidence of my investigation into Mr. Kim's serious misconduct. Mr. Kim became friends with an individual named Andy Lee when they were in the 9th grade. They remained friends after Mr. Kim joined the sheriff's office. Mr. Lee was a criminal and ultimately became the enforcer for Raymond Chow. Mr. Chow was the leader or dragonhead of an organized crime syndicate in San Francisco's Chinatown. Mr. Lee committed crimes such as arson on behalf of Mr. Chow, who also ordered Mr. Lee to kill people, break their legs, and to commit armed robbery. Although Mr. Kim knew that Mr. Lee had convictions and spent time in prison, they maintained a close personal relationship. Mr. Lee had introduced Mr. Kim to Mr. Chow. In March 2014, after an extensive undercover operation, the FBI arrested Mr. Lee. The FBI seized a ballistic vest they found in Mrs. Lee's vehicle. The federal court found that pretrial detention of Mr. Lee was justified based on its finding that Mr. Lee was a danger to the community. The court specifically relied on the charges against Mr. Lee, which involved firearms and narcotics trafficking, that Mr. Lee was a convicted felon in possession of a ballistic vest, and that Mr. Lee was an enforcer for an organized crime syndicate. Over the summer of 2014, Mr. Lee sought his release from jail, arguing the vest was Mr. Kim's vest, not his. Mr. Lee's lawyers asked Mr. Kim how Mr. Lee obtained the vest. Next slide, please. Mr. Kim fabricated a story to Mr. Lee's lawyers and then signed a declaration on August 6, 2014, quote, under penalty of perjury under the laws of the state of California, end quote, as being, quote, true and correct. In the declaration, Mr. Kim identified himself as a San Francisco Sheriff's Office employee. The declaration stated he dropped off the ballistic vest that his sheriff's office had issued him at Mrs. Lee's hair salon with Mr. Kim's wife. Mr. Kim's wife forgot the vest at the salon. Mrs. Lee took the vest, placed it in her car, and intended to return it to Mr. Kim. And the declaration further stated that although Mrs. Lee made plans to return the vest to Mr. Kim, quote, both got busy and plans fell through, end quote. In addition to creating this make-believe story, Mr. Kim recruited his wife and Mrs. Lee to commit to this web of lies and submit false statements to the court. This is more than, as counsel for Mr. Kim stated, wearing, quote, blinders when it comes to close friends or family. On August 19th, 2014, FBI special agents interviewed Mr. Kim about his version of events relating to the vest. He told the FBI the same lies he provided in the declaration he filed with the court. Mr. Kim's story was material to Mr. Lee's submissions to the court. The court denied Mr. Lee's request for release. Next slide, please. In December 2014, the FBI again interviewed Mr. Kim about the stories in his declaration. This time, Mr. Kim told the FBI that he lied to them in August and in the declaration. Next slide, please. On May 25th, 2018, Mr. Kim pled guilty to contempt of court. In support of his plea, Mr. Kim stated that he knowingly and willfully lied to the court. Next slide, please. On October 12, 2018, the court entered a judgment of conviction. Mr. Kim also submitted a memorandum to his supervisor at the sheriff's office in which he repeated the lies that he told the FBI agents and that were contained in his declaration. Although my investigation was unable to obtain the memorandum he submitted to his supervisor, and his supervisor, who's now retired, did not respond to my request for an interview, Mr. Kim admitted that he lied in the memorandum. These admissions also serve as evidence of his dishonesty relating to reporting or investigation of peace officer misconduct. The evidence above and as detailed in the ISF, therefore, substantiated at the clear and convincing standard that Mr. Kim lied in Mr. Lee's prosecution, to FBI agents during a criminal investigation into his own conduct, to the court, and to his chain of command. Reasonable grounds exist to revoke or suspend Mr. Kim's peace officer certificates. His lies had impacts in the following ways that demonstrate that his certificates should be revoked. Mr. Kim's lies obstructed justice in the prosecution of Mr. Lee. They interfered in the proceedings of another branch of government and affected the integrity of the judicial system, wasting the time and resources of the court, the prosecutors, and the FBI. Mr. Kim enlisted others in his criminal activity. This activity demonstrated that Mr. Kim had a conflict of interest and willingly compromised core law enforcement values based upon personal loyalties. Mr. Kim's lies to his own chain of command harmed the morale of the sheriff's office and undercut departmental discipline. Mr. Kim's lies were an attempt to gain release of a man the court found to be a danger to the community. Next slide. Finally, in his memorandum in aid of sentencing, Mr. Kim's lawyers stated that Mr. Kim resigned from the sheriff's office with, quote, no intention of returning to law enforcement. His own family also submitted statements that Mr. Kim's atonement included accepting responsibility through the act of relinquishing a career in law enforcement. Mr. Kim's re-entry to law enforcement demonstrates further dishonesty. Before concluding, I'd like to talk a little bit about the procedural aspects of this case. In accordance with California Penal Code Section 13510.8, G1 capital B, Post can initiate proceedings to revoke or suspend an officer's certification for conduct occurring prior to January 1, 2022, where the serious misconduct is dishonesty. Here, the serious misconduct occurred in August 2014 through December 2014, when Mr. Kim filed a false declaration with the court and lied to FBI agents, and in 2018, when Mr. Kim was convicted. As a separate but related issue, San Francisco's Sheriff's Office was not obligated under SB 2's provisions to report Mr. Kim's dishonesty to Post because the mandatory reporting became effective January 1, 2023, and Mr. Kim's serious misconduct and his employment had ended prior to that date. Next slide, please. Post initiated this investigation pursuant to its authority under California Penal Code Section 13510.8 C3C. This section states that the division may, in its discretion, investigate without the request of the commissioner or board any potential grounds for revocation of certification of a peace officer. Post received a public records request that alerted Post to Mr. Kim's conviction, and the division reviewed the matter for possible disqualification under California Government Code Section 1029. The division determined that Mr. Kim was not subject to a 1029 disqualification. After reviewing court records, however, the division initiated this investigation to determine whether Mr. Kim's conviction for contempt and underlying conduct constituted dishonesty. In addition to the division's initiation of the investigation, in January 2025, Post received an anonymous complaint from a member of the public that Mr. Kim was convicted and had agreed not to reapply for a law enforcement position. Thus, even if the division had not initiated its own investigation, it would have investigated pursuant to the public complaint. Final slide, please. In sum, the division seeks revocation of Mr. Kim's certificates based on his dishonesty for lying during the prosecution of Mr. Lee, during the criminal prosecution into Mr. Kim's crimes, and based on Mr. Kim's dishonesty during an investigation into Mr. Kim's misconduct as a peace officer. That concludes my presentation. Ms. Woolley and I are ready to answer any questions that members of the board or chair may have.
Thank you. I have a couple of questions. I want to make sure I understand this. There was some question about Sheriff Miato's letter of recommendation. The questions emerged because it was an email, it was unsigned, and it wasn't on letterhead, correct?
That's correct.
Okay. Did anybody, I know that the counselor, the psychologist or psychiatrist, I don't know which he is, said that he was possibly going to check up on that. And it appears he did not check up on that as far as we know. Did anybody ever contact Sheriff Miyato and ask if that in fact was what he wrote?
I did not interview Sheriff Miyamoto. I determined that that was not part of the investigation to the extent that Ms. Masters, counsel for Mr. Kim, had submitted certain evidence to us that in the metadata showed that it was written by Sheriff Miyamoto, so I didn't pursue that line of inquiry.
Okay, so is there any doubt in your mind then that Sheriff Miyato wrote that?
Again, Madam Chair, that part wasn't part of my investigation. So to the extent that the evidence that I did uncover in this investigation showed that there was a conflict in the evidence. On one hand, the background investigation unit investigators said that when they spoke with Dr. Dunnigan, he said that he was going to call the sheriff. When we interviewed Dr. Dunnigan, he either said he did not recall or he did not reach out to the sheriff in order to vet that out. But the
Okay.
background investigators were suspicious of that letter also.
Okay, so I understand the suspicion. I also understand that his counsel provided documentation that supported that it was in fact written by him, or what was it that his counsel said to you that made you decide not to call?
So prior to the writing of the ISF, I had already made the decision not to reach out to Sheriff Miyamoto. After we interviewed Mr. Kim, his counsel provided information to us by way of email that are contained as attachments to the
Right.
ISF. And in those, we looked at the metadata and we determined it seemed credible.
Okay, so as far as we know, that the statements that were emailed by Sheriff Miyamoto were in fact his statements.
Correct.
Okay.
And just for clarity's sake, Chair Dudley, those are exhibits 35 and 34 to the ISF. They're in the agenda packet.
Right.
They showed that the email, which included the letter, was sent by Sheriff Miyamoto.
Okay, I want to be clear about that because it continued to still be an issue in the letter that we all read on October 7th, and just want to clarify that. I also wanted to clarify the first time Mr. Kim was interviewed by the FBI, he lied about the situation. And then did Mr. Kim reconnect or recontact the FBI and say, I want to come and tell you the truth now? How is it that the second interview occurred? Whose idea was it?
According to the FBI's 302, it was a proffer session. And
Right.
according to Mr. Kim, it was on his own initiative.
Okay. Would you tell everybody the difference between a proffered session versus his own?
It's a legal question. I
Okay.
think I'll defer to Ms.
Okay. Counsel?
So a proffer is when prosecution makes you an offer that you will cooperate with the prosecution with an ongoing prosecution, either your own or with somebody else's. So in this case, because we don't have the proffer agreement, we don't know if the proffer agreement involved Mr. Lee's prosecution or whether it was an agreement regarding potential prosecution of Mr. Kim. But generally speaking, a proffer agreement involves some sort of terms where the prosecution will say, we will not prosecute you, or you will do X, Y, and Z, and then we will give you this in return. So we don't know what the details were here, but it is a contract. It's a legally binding contract, particularly in federal court. So for the line in this December 302 is what Mr. Sherwin calls it. What that means is that there was a deal reached between the federal government and Mr. Kim.
There's no evidence, no documentary evidence that indicates that it wasn't Mr. Kim who suggested meeting with the FBI so that he could tell the truth this time, is there?
My investigation did not uncover
Okay.
that documentary evidence.
Okay. Then at the time that Mr. Kim lent / gave the vest to Mr. Lee, is there any evidence that Mr. Kim knew that Mr. Lee was still involved in any criminal acts?
I don't know the answer to that. I think Mr. Kim said that he was not aware that Mr. Lee was still involved in illegal activities. But I'm not familiar enough with the criminal case, prosecution case of Mr. Lee to answer that question fully.
Okay, Mr. Kim said that he thought Mr. Lee was going to work as a security guard, and that was why he gave it to him. Is that correct? Okay. And lastly, when Mr. Kim pled guilty to the misdemeanor, he said he had no intention back in 2016. He said he had no intention of seeking employment with the San Francisco Police Department, correct?
With any police
With any
department or
police
law
department.
enforcement agency.
Okay. But the word he used was intention, and it was based on 2016. He didn't say he would never do that again, right?
Correct.
Okay, I just want to make sure I understood, because there are so many details here and so much information, and you did a very thorough investigation, but I wanted to make sure I understood all those points. Okay, let me open up to the rest of the board for questions. Yes,
No,
Sheriff Doyle.
I just had an observation that about the authenticity of the letter, since the sheriff,
The sheriff's letter?
yeah, the sheriff overruled all of the chain of command up to him by approving the hire. And it also seems to me kind of unprecedented that you would fail a psychological and just based on a letter saying this is a good person, that the examiner would overrule or change their finding. And I was just wondering if Post would have a concern about this person that's doing law enforcement psychologicals.
I think that question is beyond the scope of my investigation. Dr. Dunnigan's testimony, when we talked to him, said that there were two parts to his evaluation. One was based upon his psychological evaluation, and the other was an examination of the dimensions. And if it was his lane in the road, that is to say, mostly his lane in the road, that clinical psychological aspect, then he kind of owned that lane. But he gave great deference to the sheriff when the sheriff wrote in, or a chief, however it might have played out. In this case, it was the sheriff, that he gave great deference if that individual was willing to take a risk in hiring the individual based upon their review of the post dimensions, then he said, that's up to them on the hiring
Please
side.
go ahead, Chair.
Well, I guess I just find the whole thing unusual because being the sheriff for 26 and a half years, I don't remember ever doing anything but reading psychologicals when they were completed and submitted for hire. So I mean, maybe that's more of an observation, but I'm just wondering if Post, not you, as the investigator, would have some concern about this examiner based on they're probably going to be doing, or he's probably going to be doing more in the future.
I will attempt to answer that question. The discussion did come up, and having worked at the Department of Consumer Affairs for over 20 years, where licensed psychologists that's the regulatory oversight. I think what you're bringing up is a conflict of interest in terms of the sheriff, chief, regardless of who it is, that's head of the agency, should not be practicing psychology and making determinations on mental suitability. That rests with the licensee who's charged with doing that. So from my perspective, it does bring up some concerns in terms of a conflict. You want to make sure that that is separate and apart from the hiring decisions. Whatever that suitability or non-suitability judgment is that of the licensed individual who's making the call. So I understand your concern.
Okay, I think Ms. Hatcher Crawford would like to speak, and Dr. Glazer, so go in that order. Ms.
So
Hatcher
in reviewing this case, I think a couple of things were really concerning, that we're even sitting here looking at this case, because it was, again, policy Post. It was one of those issues that was brought up, that if he was already terminated, how was it that the San Francisco Sheriff's Department decided to rehire him? And that just kept popping up in my mind. And one of the statements, I don't recall the regulation or public thing you put in there. It was very clear in Post about the rehiring of officers. And I was just baffled in reading the case. And that was my statement. And that was my thought, that if you are dishonest this once, you will probably be dishonest again.
You just wanted to share a thought or feeling. You don't have any question for the investigator, right?
Not really. I think they did a wonderful job.
Dr. Glazer.
Just to get clarity, the letter from the sheriff, from Sheriff Miyamoto is just addressed to whom it may concern. And I think from Mr. Kim's attorney, it sounds like Mr. Kim showed the letter to the psychologist. Is that correct?
That is correct.
Okay, so we don't have any information that indicates that the sheriff communicated with the psychologist.
Correct.
Okay.
There were actually two versions of the letter, according to the email that Ms. Masters provided to me. In one, the Word document was labeled letter recommendation captain, or words to that effect. And the second was letter recommendation sheriff. So when now Sheriff Miyamoto was a captain, at some point he must have written this letter at some historical point in time.
Thank you.
I guess.
Yes, Mr. Johnson?
Yes, Johnson. You know, I was really taken away too with the fact that the sheriff actually wrote the letter, if he in fact did, but also everyone rejected hiring him except for the sheriff. So, I mean, I don't know, you know, it just, I guess my thoughts messing with me concerning that, but the 4 individuals or 3 individuals that rejected hiring him, and then Dunnigan changing his mind and approving that he's fit basically for duty. And then Akamoto, is that how you pronounce it? Miyamoto. Overruling everybody and hiring him. I guess he has that right, but that's problematic.
Just clarify one thing for the record. Board Member Hatcher Crawford, Deputy Kim did not get terminated from the San Francisco Sheriff's Office back in 2016. He resigned. Right.
Okay, any other questions from the board? Okay. Seeing none.
I do have one. So while he was unemployed, he, I think, was working for a security company. I forget exactly, but there was some sexual harassment allegations. Did he actually get through both of those cleanly?
He did. So after he left the sheriff's office, he did a variety of jobs, but ended up at the San Francisco War Memorial, which is a city and county employee also. And while there, he was under investigation for a sexual harassment incident. He was cleared of that. And that was one of the reasons why in his background check, Dr. Dunnigan had stated that he had failed him initially during his first evaluation.
Any other questions on the board? Dr. Glazer?
One more clarification with respect to his status with the department in the first phase. He resigned, but is there any reason for us to infer from that he was not under any disciplinary review, or that there was any possibility that he would have been terminated?
I think that would be just speculation because he resigned, but I'll see if there's any.
Maybe if there's some clarification on the timeline of that and yeah, anything to that effect.
Investigators?
May I comment on that? At that time, until SB2 came into being, now departments are required to complete internal affairs investigations. At that time, they were not. So currently, the departments are required to complete an internal affairs investigation irrespective of employment status. At that time, because he resigned, in the ISF, I note that there was, and the records policies of departments also come into play here, because after 5 years, if there's a non-finding, then it's not sustained, then they purge their records. So given the time frame that we're talking about, it's a little difficult. But there was some evidence that they had started an investigation, and then there was some, I think, some comment in the media that the sheriff's office had said, we're not going to comment on it. It's a personnel matter, and then it ended up being closed.
Anything else from the board? I'll come back and ask you that question again. Let's move on to the next part. At this time, does the subject officer and/or counsel wish to make a public statement? If so, you will each be given 5 minutes to speak, and the time limits will be strictly enforced. so please ensure that you complete your comments within the allotted time. While commenting, keep in mind that the board will only consider the facts as presented by the division today and will not consider any additional facts or defenses at this time. The sole question before the board today is the following. If the facts offered by the division today are proven at a later hearing, do those facts demonstrate clear and convincing evidence, a high probability that serious misconduct as defined in Penal Code Section 13510.8 and Commission Regulation 1205 occurred? Let me say before I ask about those additional comments, let me just comment that, or let me just ask, has every board member read the October 7th letter that was distributed to all of us? Is there anyone who hasn't read it? And so you can take some time now to read it. I just want to be able to tell Ms. Masters that in fact she doesn't need to reiterate anything that was in the letter. Okay, looking at all of you, there's no one that has not read it or does not need time to review it. Okay, having said that, Ms. Masters, please feel free to say anything you want, but I did want you to know that we read the letter.
Good afternoon. Thank you for clarifying that. You beat me to it. I was just going to say that in the interest of time, I won't be reading the written public comment into the record since all the board members have reviewed it and it's clearly part of the record already. I would just briefly like to point out just a few things. First, the fact that Deputy Kim was rehired, and our position is that it just supports the mitigating facts that were outlined in the written public comment and goes to show that he had earned a substantial amount of trust with his department before this incident. And since his rehiring, obviously they continue to trust him if he was still rehired. The second point is again regarding this letter of recommendation. I think it's hopefully now been made clear that there really is no conflict in whether that letter is authentic or not, but all the speculation by the division that led up to it really did make it part of the investigation. And frankly, instead of speculating on the matter and potentially bringing, this prejudicial question of the letter into this investigation, it would have been easier just to directly interview Sheriff Miyamoto and quash any questions about the letter's authenticity just straight away. The third point is it's clear, at least in my opinion, that Post has ventured outside of the decertification inquiry and scope here. Clearly disapproves of the sheriff's office's hiring practices by way of rehiring Deputy Kim. But again, in doing so, left the scope of the decertification inquiry. Specifically, just getting into the level of detail that there was regarding the psychological background, just to me clearly seems like it's part of the hiring process with the sheriff's office, not an inquiry into decertification. And I'm concerned that the only purpose in doing so was to essentially provide prejudicial, irrelevant material. The next point is that I think the question was asked earlier, I don't recall who asked it, but there is no evidence in this record that Deputy Kim knew Lee was still involved in illegal activities. To the contrary, I mean, Deputy Kim earnestly stated during his interview that he honestly thought and hoped that that Lee had essentially left the organized crime world and was on the path to actually doing something productive with his life, in essence, and that's where the comment about wearing blinders with family or friends came from. The last point, I would just like to reiterate the requests in the written public comment that we submitted to consider the mitigating facts outlined. And I'm happy to answer any questions that the board may have about any of those clarifying points that I brought up.
You'll have 1:48. Is there any for your comments alone, which stops the clock when the board starts asking questions? So is there anything else that you want to say?
No, I think everything else is contained in the written public comment at this time.
Okay, thank you. Okay, board members, do you have any questions for Ms. Masters? Okay, apparently they don't. So would you like to make an additional statements now?
No, ma'am. Thank you for offering.
Sure. And does your client want to speak?
No, he is not present with me today.
Okay. Um, one moment, please. Okay, at this point, then, does the board want to adjourn into a closed session for deliberations? Okay, seeing one person nod, we will do that. The meeting will adjourn into closed session for deliberations on the case. The board members will now exit the room and be back for regular session shortly.
Let's go, you know, kind of deal, yeah.
Maybe something going on.
Waiting for the court reporter. And I told her to take her time, so it's on me. Thank you. You ready? Okay, wonderful. Okay, we will now reconvene to regular session to take a vote on the board's recommendation in the matter of the case of post 2410050 Michael Kim, who at the time of the events at issue in this case was and still is employed with the San Francisco Sheriff's Office. Does the board have any comments to make on this matter?
Doyle, I motion to decertify.
I'm sorry.
Doyle, motion to certify.
Okay, is there a second?
Second.
Okay. Ms. Essex, will you take a roll call vote? Let me just ask, before we do that, is there any further comments, questions, abstentions? Seeing none, Ms. Essex, will you take a roll call vote?
Clavo.
Aye.
Clavo, aye. Crawford.
Aye.
Crawford, aye. Doyle.
Aye.
Doyle, aye. Dudley.
Yes.
Dudley, aye. Glacier.
Aye.
Glacier, aye. Johnson.
Aye.
Johnson, aye. Laura.
Aye.
Laura, aye. That's 7 ayes. Motion carries.
So the motion passes.
Yes.
Thank you. Okay, we're going to move on to the next case. I don't think we need a break. Okay, at this point, I will now call upon law enforcement consultant Marcus Gregory, Professional Conduct Southern Bureau, and Brian Hoffman, attorney for Legal Affairs Bureau, to provide a report on post 240-2562 and Armando R. Montalvo, who at the time of the events at issues in this case was and still is currently employed with the Orange County Sheriff's Office. Gentlemen.
Good afternoon, Chair and members of the board. My name is Marcus Gregory, and I'm one of the law enforcement consultants assigned to the Professional Conduct Southern Bureau and the Peace Officer Standards Accountability Division. With me today is Brian Hoffman, an attorney with our Legal Affairs Bureau. I'm here today to present post case number 240-2562 involving Orange County Deputy Sheriff Armando Montalvo. It is the division's determination that clear and convincing evidence exists to demonstrate that Deputy Montalvo committed an act of serious misconduct as set forth in Penal Code Section 13510.8 on March 16, 2024. Specifically, the division has determined that Deputy Montalvo committed the following acts of serious misconduct. 13510.8, Parent A, Parent 3, physical abuse to include excessive or unreasonable force. In this presentation, I'll present a brief outline of the division's finding of investigation in this matter. Deputy Montalvo began his career with the Orange County Sheriff's Department on February 25th, 2022 as a deputy sheriff in training. Deputy Montalvo graduated from the academy and became a deputy sheriff on September 9, 2022. Deputy Montalvo remains employed with the Orange County Sheriff's Department, and Deputy Montalvo has obtained both a basic post certificate and an intermediate post certificate. Deputy Montalvo has 5 other reports of serious misconduct of record with post related to claims of excessive or unreasonable force. 4 of the 5 reports have all been determined to be unfounded or not sustained by the agency and have been closed with post. The 5th investigation, post was notified on October 2nd, 2025, that case was not sustained but has not been investigated by post at this point. Orange County administrative investigation in this matter did not note any other forms of discipline imposed on Deputy Montalvo. California Penal Code 13.5, 10.8, Parent B, Parent 3, and California Regulation 1205A3 defines physical abuse as including but not limited to the excessive and unreasonable use of force. Slide. On March 16, 2024, Deputy Armando Montalvo was involved in a use of force incident with an inmate at the Orange County Intake Release Center. As part of his duties that day, Deputy Montalvo would oversee inmates going through the booking process. Deputy Montalvo was escorting an inmate, who I will refer during this presentation to as an inmate, to the photo booth when the inmate became resistive by turning towards and pulling away from Deputy Montalvo. Deputy Montalvo and another deputy responded by taking inmate to the ground. During the use of force incident, Deputy Montalvo punched the inmate approximately 28 times in the face, head, and upper body, while 3 other deputies assisted and threw numerous punches. The inmate was not assaultive towards deputies and was only showing passive resistance by not giving up his hands while pinned in a prone position on the ground. At one point after delivering the punches, Deputy Montalvo lifted the inmate's head and struck the inmate's face against the concrete floor while the inmate was pinned down by other deputies. During his administrative interview, Deputy Montalvo stated he got tunnel vision after he believed the inmate had struck him in the face and had refused to follow commands and put his hands behind his back. Deputy Montalvo stated he felt the inmate was trying to fight him at that point. Deputy Montalvo explained that he used injuring force because while they were still standing up, he couldn't get the inmate in control holds and didn't know what other force options to use. Deputy Montalvo stated during the heat of the moment, he believed injuring force was the best option. Deputy Montalvo acknowledged that looking back at the incident now, he probably should have used different tactics. Deputy Montalvo admitted that grabbing the inmate's head by the side and striking it against the ground was not an approved use of force technique. Next slide. Deputy Montalvo was cooperative with the investigation and acknowledged that the use of force used during the incident was excessive. As a result of the administrative investigation, the Orange County Sheriff's Department sustained a finding that the force was not within policy. As a result of the sustained finding, Deputy Montalvo received a 40-hour suspension. The facts I've just recited support the division's finding that Deputy Montalvo was involved in serious misconduct, specifically physical abuse, to include excessive and unreasonable force. The purpose of the division's analysis, clear and convincing evidence, means evidence of a charge is clear and convincing so long as there is a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. The division recommends that Deputy Montalvo's post-certification be either suspended or revoked. The division's recommendation is based on the following factors. Deputy Montalvo's actions constituted physical abuse when he used excessive force against the inmate by punching him 28 times and striking his head against the ground. The involved inmate advised the sergeant investigating the incident that he did not have any injuries. At the time the event took place, Deputy Montalvo had only approximately 15 months off training. Deputy Montalvo initially believed his actions at the time were justified, as did his partners when the incident occurred, which identifies a possible training issue. However, upon further review, Deputy Montalvo acknowledged that his actions did not comply with his agency's policies, and he admitted that he used excessive force. He admitted he suffered from tunnel vision because he thought the inmate had struck or attempted to strike him in the head. Deputy Montalvo admitted to the misconduct during the administrative investigation and did not make excuses for his conduct and appeared remorseful for his actions. When reviewing the incident during the administrative interview, Deputy Montalvo admitted that his actions would not look good if observed by the public because he threw too many punches and it did not allow the inmate time to respond and give up his hands. Deputy Montalvo stated during the administrative investigation that he sought out additional training following the incident. Deputy Montalvo accepted the proposed discipline issued by his agency and did not file an appeal. Deputy Montalvo has no further discipline history, and Deputy Montalvo's candor, acceptance of responsibility, and action of seeking further training indicate he is willing to learn from the incident. Next slide, please. We're going to show a video of the use of force incident, and following the video, I'm happy to answer any questions that the board may have.
I have a couple of questions. Prior to this offense, were there 5 or 4 complaints about him using excessive force?
Prior to this incident occurring, there were 3 other reports.
Okay. So why has there been a number 5 and 4 thrown around? I'm confused. I thought 5 out of 4.
There's a total of 5 additional reports. 3 occurred prior to this incident occurring, and 2 had occurred after that. 4 had been unfounded and cleared out by post, and the 5th case had not been cleared out by the division, or we did not receive any information that had been cleared out till October 2nd of this year.
So of the 5, is this one of the 5?
This case?
Yes.
No.
Okay, so there were 5 prior complaints of abuse of excessive force. And we still don't know the findings of it, one of the 5.
We know that that was determined to be unfounded, not sustained as of October 2nd of this year.
Okay, so there were 5 complaints of excessive force, not including this one.
Correct.
Can you tell me anything about those other 5?
I can tell you that 4 of those 5 did not have anything to do with punching the subject. Or Deputy Montalvo was not identified as punching that subject. And that all those cases did not even get to the level of going to internal affairs with Orange County Sheriff's Department.
So he didn't punch, but what did he do? What is he alleged to have done?
Well, in some of them, he was alleged to have used control holds, body weight.
Okay, so it's very important to me that we break down those 5 instances. So you're telling me that in 4 of the 5, there was no punching. What about the 5th?
The 5th one indicates that he did punch in the case. It doesn't identify how many times. Post has not looked at that investigation yet.
Okay. So Post is still planning on looking at that investigation?
Will have to be looked at some point, yes.
Okay. Of the 4 that we know about, there was no punching, but can you tell me anything besides the fact that he used incorrect holds that brought it to a level of a complaint? I understand they were all unfounded, but just what brought it to the complaint level?
I believe that they were all inmate grievances or were pushed up to the command level to take a look at.
When you say pushed up to the command level, does that mean a fellow deputy made the report?
No, all I can tell you is that a commander reviewed the findings, where in some of the cases, they were cleared out with just the use of force report that went from the sergeant to the lieutenant to the commander.
So of the one we don't know about, of the four we do know about, there was no punching, there was some allegation. We don't know by who, but it might have been an inmate in each of those other four.
I believe they were all allegations from an inmate.
Okay. Do we know if they were the same inmate or different inmates?
I believe they're all different.
They're different, all four.
Correct.
Okay. Questions?
Question.
Hang on, let's go to Sheriff Doyle and then on to Dr. Calla.
Could you clarify, because in findings, unfounded means it didn't happen. Not
Correct.
substantiated means there's not enough information to say it happened or it didn't happen.
Correct. I'm just telling you the way the Orange County Sheriff's Department submitted it to us.
We don't know, to go with Sheriff Doyle's comment, we don't know if it's unsubstantiated or unfounded. We just know that's the language they used.
Yes, in some of the cases, obviously, the force occurred, but they did not sustain any kind of complaint. They're submitting it to post because they're required to submit any kind of complaint.
Well, I guess I'm confused because in our organization, unfounded meant it didn't happen.
Right.
So, okay, thank you.
It looks like we don't have a definition of it.
Can I just on that point?
Let me just go with Dr. Calvo and then next to you, Dave, Doctor.
I kind of forgot my question, but he's trained in jiu-jitsu. Was that, I heard in the interview, was that correct?
He was taking some training before the incident and then stated during his interview that he started taking more of it after the incident.
And how long had he been an officer at the time?
Approximately 15 months he had been off training.
And did the other instances have video or no video?
I can't tell you because I did not investigate those cases.
Okay, thank you.
Dr. Glazer.
It is my understanding that the use of unfounded varies from agency to agency and that it's not consistently meaning there's an absence of.
Sorry, I misheard.
It's not consistent across agencies that the unfounded designation means that it's an exoneration.
That's correct.
And I would also want to know if we have any information about what their standard of evidence is for unfounded at that agency, because ours is clear and convincing.
I don't know that.
Okay. And looking at the attorney, do you know that?
I don't know it either.
Okay.
Not in Orange County specifically.
Okay, thank you. Anything else, Dr. Glazer? Well, hang on, Dr. Glazer, anything else? Okay, then next, Mr. Johnson, and then Ms. Hartford.
Yes. So if I heard correct, it was 6 incidents, 3 before this one and 2 after this. He had been employed total time right now 15 months. How close in proximity the first 3 incidents occurred before this particular incident?
I think you had a timeline in there.
The first reported incident was May 9th, 2023. The second was June 4th, 2023. December 14th, 2023. The incident we're discussing today occurred on March 16th. And then there's March 21st, 2024 and September 20th, 2024.
Anything else, Mr. Johnson?
Yes. On those 3 priors, were the designation unfounded, or what was the designation of those?
I have the first one as unfounded by the agency closed with post. On the second one, I have unfounded and exonerated. On the third, I have unfounded by the agency. On not including our case, the next one was unfounded and I have not sustained on the last one.
Was this case is before this board, was that found unfounded?
No, that was sustained.
Okay.
And then the last part of my question, I think Dr. Quabble did ask, on all these incidents, there were no cameras involved, no video recording?
I did not investigate those other cases.
So I would say that your question almost the same. So I'm trying to find in this one line. 6 of them, you gave us the dates. They were within the 6-month period from each one of the cases, total of 6 incidents, alleged incidents. And you may have said this already. And like I said, I'm trying to find in this one line. Of the 6, the unfounded ones were by the agency or post.
4 of the other 5 cases have been closed out by post as
They were
well.
closed out by post. So they were investigated by post.
Correct.
You mentioned, so then the other 2 were unfounded by the agency. So I'm trying to figure out which ones were by agency versus post and their determination, basically what I'm trying to get.
The only case that has been submitted to post that has been sustained by the agency is the one that we are discussing today.
Okay.
As far as I understand it, there's another one that post is not yet investigated. Okay, so
Right,
there's
and
this
2
one.
of them involved punching, correct? Or not hitting, I'm gonna say hitting. Punching sounds a little strange.
The final case that was submitted to post on October 2nd that we have not conducted the investigation on there indicated that Deputy Montalvo had used a punch.
Okay, and then the other 4 did not involve any physical altercation or anything.
I can't tell you about physical altercation. I can tell you that none of the cases described any punching taking place by Deputy Montalvo.
And post-evaluation, post-standard for a finding is clear and convincing. And just to be clear, post doesn't exonerate. Is that correct? The 4 cases that post considered, post did not go further on the case because it didn't meet the standard of clear and convincing. But post does not exonerate. I'm trying to make this clear for the board.
Correct.
Okay.
Can I get clarification on that point, which is the closures by post, were those the result of an independent investigation by post, or were those the result of the unfounded findings by the agency?
Somebody would have looked at the cases here at post.
And it would have to rise to the standard of clear and convincing in order for post to proceed. Other questions?
I would be interested in knowing on the 4 that post did close, whether there was video footage.
Do you happen to know
He
that?
wouldn't know. He didn't investigate it.
Okay. Well, post investigated it.
Yes.
So let's see what the assistant
Right.
executive director.
So this goes back to those P3 closures that we talked about where there's an abbreviated review. If they are exonerated, unfounded, not sustained, we review the course of the crux of the case, meaning the agency's internal affairs investigation, and look at the findings as to how they got to the point of not sustained or exonerated, unfounded. So it doesn't require video review in all of those cases. We go back and audit those cases, specifically if we've got instances where we have multiple cases involving the same officer, we will pull those cases for audit. Whether or not this one came up from an audit perspective, I don't know because I don't have the audit sheet in front of me. Typically, those cases that involve, like I said, multiple cases against the same officer would come up for a P3 audit. In this particular case, I want to speak to something Dr. Glazier asked is what was the burden of proof on the part of the agency? In terms of them taking any kind of administrative action, disciplinary action, it would be preponderance. I think what Mr. Gregory was pointing out is some of these cases may not have been complaints, charges, or allegations, but they're reports of use of force that get reviewed by the agency as potential excessive use of force. Orange County submitted those cases to post, even though they may not be an actual complaint. Now, those that there's a grievance by an inmate, I would suggest those are complaints and they need to be forwarded to post like any other complaints would be forwarded. So just to keep in mind, I think Chair Dudley asked the question as well, what does it mean that they've gone through a review and a commander has reviewed it? Any incident of use of force
my experience in jail or prison setting is going to require some review by the commander or the lieutenant in that particular housing unit to look at whether or not the use of force was justified, was it within policy, et cetera. So some of that may have landed with post based on that review, and then there was a subsequent grievance, and so that's why we're reviewing the case.
Yes, Mr. Johnson.
So his entire sheet or incident 6, all were centered as an in custody deputy?
Correct.
Other questions from the board? Okay, I'll proceed, and we could always come back to more questions. This time, does the subject officer and/or their counsel wish to make public comment? If so, you will each be given 5 minutes to speak, and the time limits will be strictly enforced. Please ensure that you complete your comments within the allotted time. While commenting, keep in mind that the board will only consider the facts as presented by the division today and will not consider any additional facts or defense at this time. The sole question before the board today is the following. If the facts offered by the division today are in fact proven at a later hearing, do those facts demonstrate a high probability that serious misconduct as defined in Penal Code Section 13510.8 and Commission Regulation 1205 occurred? With that said, is there anyone from the public who would like to address the board at this time? When it is your turn, you may state your name and organization if you wish, and you will each be given 5 minutes to speak, and the time limits will be strictly enforced. So please ensure that you complete your comments within the allotted time. So let me start first with, is there an attorney or
Yes, Madam Chair. This is Brett Rukowski, attorney for Deputy Montalvo, and Deputy Montalvo is with me as well.
And is Deputy Montalvo with you?
Yes, ma'am.
Okay, please go on.
Yes. Yes, ma'am. Like I said, good afternoon. And to members of the board, my name is Brett Rukowski, and I represent Deputy Montalvo. Just to begin with, to discuss what was mentioned earlier regarding the 6 investigations or the 6 complaints. This incident here that we're here for today is the only time my client has been interviewed in any capacity regarding any misconduct allegations into a use of force such as this. The other items that were discussed, the other 5, he was never interviewed on. And to be honest with you, I do not know the actual fact pattern behind any of those instances, but I can say that this incident here is the only time that my client was ever subject to an internal affairs investigation. I'll continue on. We are here today because the Orange County Sheriff's Department sustained an allegation of excessive use of force and, consistent with SB 2, reported the matter to Post. The department took that obligation seriously. They conducted an internal affairs investigation, reviewed all evidence, and imposed the discipline, which was a 4-day suspension. And as you heard, Deputy Montalvo still works as a deputy with no restrictions in the department. The department's evaluation of this case was not made lightly. It was reviewed and signed by one assistant sheriff and a commander who is now an assistant sheriff. These are law enforcement executives who understand the gravity of excessive force and the public trust that goes with the badge. There is nothing in this record, nothing suggesting that there was any minimizing of the conduct, ignoring Deputy Montalvo's obligations and duties, or trying to quote unquote sweep misconduct under the rug. The reason why I bring that up, because it has been suggested at times that the board or the commission is not beholden to any agency's discipline because of concerns that some agencies may try to do just that. There's absolutely nothing in this record to support that fear. There is no evidence, none, that anyone in OCSD's command were trying to do just that. I want to make perfectly clear, the 40-hour suspension was the original deliberate decision by OCSD leadership. It was not the result of a Skelly hearing or some backdoor deal or settlement agreement. This is what they felt. And my concern with this case is that I believe it's important to understand why they came to that decision, because at the end of the day, a decertification is a termination. I mean, we can use nice words, but at the end of the day, it's a termination for Deputy Montalvo to not operate as a peace officer within the state of California and arguably in the United States. But an agency like the Orange County Sheriff's Department, who still employs him, felt 40 hours was appropriate. And why? In my opinion, it's because it's a training issue. It's a training issue. As you've heard from the investigator on this case through post, my client only had roughly about a year and a half or less as a peace officer. And from my understanding, he was just a few months removed from obtaining his basic certification with post. And this was brought up early on in an unrelated matter here at this hearing when when the presentation was shown regarding the statistics. But something very interesting was mentioned by one of the board members, and I think it's pertinent here. You need to consider if this is a pattern with Deputy Montalvo, specifically these excessive use of forces. And I'm concerned now that you're relying on the other 5 or 6 instances to factor into that judgment. But the fact of the matter is those instances were never investigated specifically as it concerns accusing my client of misconduct. Otherwise, why was my client never interviewed? And the answer here is that this is not a repeated issue. This is a correctable issue. And I believe that was mentioned earlier during the session when all the information was being shown, that this is a correctable action. There's an opportunity to show actual correction from Deputy Montalvo. And as you heard during the investigation and the presentation, my client admitted he was not trying to run away. He believed he had tunnel vision. And for any of the law enforcement board members on there, they know exactly what that means, especially being a young officer engaged in a use of force. And that's exactly what happened here. And to decertify him would negate the ability for Deputy Montalvo to be able to show that this is correctable. Last part I'll say, and I'll be done. This is the most recent evaluation that was issued. Armando, your performance reflects an untiring commitment to excellence, safety, and service. Your leadership, integrity, and dedication serve as a model for others, and I am proud to have you as a representative of our department. That was from the leadership of Orange County Sheriffs. I thank you for your time. If you have any questions, I'll be happy to answer. I know Deputy Montalvo wants to add a few points, if that's possible.
Who signed the evaluation?
This was signed by Lieutenant Rufong, Ruffong, and then at the bottom it has an executive command signature, which I cannot read. It was dated 9/5/25, September 5th, 2025.
Okay, thank you so much.
Yes, ma'am.
We may come back to you with more questions. Do you have questions now for the attorney, or would you like to hear from Mr. Montalvo? Okay, Deputy Montalvo, please.
Hello, everyone. Thank you for having me. I just have a brief statement. I just want to sincerely apologize for my actions. As a young deputy, I know I made mistakes, so based on my lack of training. But I want all of you guys to know it was never my intention to cause any problems. I had time to think about everything, and I've learned a lot from it, which I've taken upon myself to continue training with my department and outside as work as well. I truly care about my job and the people I work with. I'm asking for a second chance to show I've grown and I can represent the badge the right way. Thank you for your time.
Your comment about a lack of training. Do you think that there is a lack of training in your decision to hit his head on the cement floor after the 28 punches? You think
No.
that would you need someone to tell you after you punch someone 28 times and their hands are cuffed or restrained that one last pound on the floor was okay?
No, I think it's just with being very young in the department and not being involved in situations like that. I think I just got tunnel vision and I can't really explain what happened. It's just when adrenaline's pumping, things happen. And
I understand that. I just want to be clear about that part, that you wouldn't need someone to train you, that
No.
was unacceptable behavior. Okay, thank you. Questions from other board members? Doctor?
Yes, so I've heard it mentioned several times, lack of training. What are you referring to, lack of training? Because when Chairwoman Dudley just asked you, you mentioned just tunnel vision, and I've heard that stated a few times through the interviews and things of that nature. So explain to me, do you feel that the academy you went through is not sufficient, or that you needed more on the job training after 14 months? I'm trying to understand the lack of training.
Obviously, in the academy, you do a lot of things. You do a lot of punching, striking. You do some arrested control techniques as well. I think based on me, my personal, everybody's different. I lack the part of using arresting control techniques. Obviously, I think that's why at that time I struck him so many times, striked him so many times, sorry, because I could not get his hands out. And that was based on my lack of training because I didn't know how to pry his arms out. Now, if you would ask me, um, I tend to stay away from striking as much as possible. I try to rely on my arrested control techniques. And obviously now I try to pause, think of what I'm doing, assess the situation, and then reassess again. That's all the stuff I've been learning from my weekly trainings as well as my outside trainings that I do.
Follow-up question. What you stated not punch or punch as least as possible. So what would define a reason for you to use punches?
Someone that's obviously being assaultive towards me. Not actively resisting, but being very assaultive.
Thank you.
Yes. Good evening. How are you doing, Deputy Montalvo? My question is, we really couldn't see in the camera, and so the camera is angled from behind. And when the gentleman was going over to take the picture, what did he do that triggered you needing to pull? I guess, assuming you were pulling his hand back to handcuff him. I'm assuming.
So normally during that procedure, we call it like the intake process. So these guys are coming in drunk and high, and sometimes they don't speak the language. So what I was doing, I clarified. I was like, "Hey man, do you speak English?" He said, "No, I speak Spanish." I was like, "Okay, I speak Spanish as well." So then I was like, "Hey," I gave him like, "Hey man, come on, stand up, walk this way, walk this way." He didn't understand. I grabbed him by the arm to try to guide him, and then he had told me like, "Hey, I don't speak English," but then he said words, "Hey, don't grab me." And then obviously he pulled away. And then from pulling away, that's when I tried to put his hands behind his back and control him. But I failed to do so.
Thank you.
Does any other board member have a question?
Yes, Johnson.
Oh, thank you.
Yes. I'm curious to know, and I'm not sure if your representative will let you speak to it, but there were 3 prior incidents before this particular one and 2 after this. There was no, to our knowledge, there was no video. To our knowledge, they were unfounded. How did you happen to be in the proximity of those 3 incidents at the time they occurred?
Normally it's either they call over the radio, "Hey, additional deputies," or you're dealing with another inmate and something else happens and you respond. So based on the whole situation, I've been involved in a lot of situations when something's taking place and something goes all over the radio and I respond and I'm the first, second one there and I'm assisting. So it's basically either call for the radio or you observe and you respond and you act upon it.
It sounds as though you actually did put your hands on the individuals.
Sorry?
You did actually put your hands on the individuals when you showed up to the scene for those 3 incidents prior to, and the 2.
Yeah. Yeah, normally if if we catch paper on a use of force, even if I wasn't involved in it, you putting hands on an inmate by placing handcuffs or grabbing his arm or playing leg shackles or leg restraints, you're automatically tied to that report.
And I just want to be clear also, we're not really familiar the fact pattern behind these other use of forces because he was never interviewed. on these. And we don't have, at least on our end, we don't have any documentation specifically on if he was just responding. And just like Deputy Montalvo said, he may have put an arm on the suspect or the inmate, and that was it. But because it was a use of force, now he's implicated, involved in it. There's a lot of moving parts to these use of forces. I'm sure the other board members, specifically the sheriff himself, would be able to speak to that, or at least provide a little guidance on that. I'm not saying for here at this hearing, but there's a lot of moving parts when it comes to a use of force and who was present, who put hands on, who didn't.
Any other questions from board members?
Yeah,
Sheriff?
Yeah, I mean, having, and I'm sure it's the same now as when I worked in the jail, which was a long time ago, is that deputies are trained really to react very, very quickly to any kind of discretion simply when, and I noticed that there were other inmates out. And so I'm assuming that jail deputies in Orange are trained similarly, that when something happens, you need to quickly resolve those things, especially when you have other inmates loose, to maintain control in jails, which are pretty unique places.
Yes, sir. Obviously, we're trained like when an altercation breaks out, whatever it is, radio transmission, you observe it, respond quickly. And it's a matter of seconds where things can go wrong. And obviously, you only have a matter of seconds to break down what's going on. Hey, what do I do? Do I go hands on? Do I go hands off? Most of the time, when you're in the jails, you don't know the inmate, you don't know what their background is, you just go hands on. And then after you discuss like what happened, but obviously, yeah, it's correct.
Thank you.
Thanks, sir.
Captain Laura, did you have anything?
I do not.
Okay, Mr. Johnson, anything else?
Yes, another question. So I understand you're in some form of training now.
Yes, sir.
These incidents will occur around you, I'm sure, in the future. How do you believe these trainings will help you not be caught up in a situation where you're under an investigation for excessive force?
For example, this morning I was at work. I'm actually dressed in uniform. I had training as well, or I had arrested control, which I try to attend every week, if not twice a week. My instructor always says, "All right, you're here. You're on the floor with the inmate. Assess. What are you doing? Do you need to back off? Do you need to give him time to respond?" Based on that, I've learned, time, give him time. Not all inmates are going to respond quickly, especially if they're under the influence of alcohol or drugs. You don't know, and you can't assume, right? Sometimes it's a language barrier, so you have to assess, give them time, back off. And like I said, I train jiu-jitsu outside of work too. It's a self-defense mechanism. It's to defend yourself. It's not pre-tact like boxing or striking. I'm trying to basically stay away from that, obviously, because I got in trouble and I'm here now.
Is there anybody else? Okay, thank you. Let's see if your counsel has something else you want to say.
No, Your Honor. I'm sorry. No, you're sorry. Different form.
I make my children call me that too, so.
I'll call you that as well, ma'am. It's all good.
Anything else? Okay, and there's no public comment in the room? Oh, there is public comment in the room. Come on up, Ms. Johnson. Ms. Johnson, if you'd sit, is there a mic there? Great.
Good afternoon.
Good afternoon.
I'm a citizen, and I would be very uncomfortable knowing that that officer was back in the community. He mentioned, what is it when you get excited? His exhilaration? Adrenaline. That's how people get killed. Adrenaline. A whole bunch of people have been killed by the police because of adrenaline. I don't think that this is the occupation for him. We cannot take chances. We have too many people being killed by the police. And if this was your only incident, to me, I would see you as troublesome. Even if you didn't get it, they didn't find something, that's a whole lot for 18 months. So I would consider you troublesome. I would not feel safe if you was in the community. You look like you smart. I feel like you should get another occupation because these words you're using in training. Training is training physical too, but they also train to protect and serve. And at no time, if you asked him, do he speak English or does he speak English? I felt like when I was looking in the video, I didn't see any aggression until you took aggression. So if you could ask him, does he speak English? Why didn't you ask him to put his hand behind his back? He might have just did it. That's protect and serve the public. So I think that I would be very nervous, and I know a lot of people would be very nervous and would not be comfortable. And I feel sorry for the community you work in because that person that you did assault, what's going to happen when he see you? You're going to traumatize him for the rest of his life. So yeah, thank you.
Thank you, Mrs. Johnson. Any other comments, public comments? Okay, any further questions before we discuss this case and questions, comments? Yes, Dr. Alva.
If my fellow board members will entertain me, can we see the video one more time?
Sure, of course.
Oh, we can watch it in closed session. No worries. I have it on my laptop or on your laptop.
Okay, let me just make sure. Can put that up or no? It's up.
Okay.
We're going to watch it here. Thank you. Any other comments or questions? Okay, let's get into discussion. Let me read something, please. The meeting will adjourn into closed session for deliberations on this case. The board members will now exit the room and be back for a regular session shortly. Thank you, everyone. now convene in regular session to take a vote on the board recommendation in the matter of case post 2402562 Armando R. Montalvo, who at the time of the events at issue in this case was and is still currently employed with the Orange County Sheriff's Department. What comments does the board have on this matter? Dr. Glazer?
I would just move that we recommend revocation.
I'm sorry.
I move that we recommend revocation of
Okay, is
certification.
there a second?
Second.
Is there any discussion, any further discussion, questions, comments? Okay,
Yeah, I do have a comment. I mean, having worked in jails, and I know that it's a totally different environment. And even though the video doesn't look good, I don't think it rises to the level of ending the deputy's career.
any other comments, questions? Thank you, Sheriff. Yes.
Well, the purpose of this committee is not to always go in and want to, you know, remove anyone's position. You never want to take on his position. But coming from my experience and things that I seen in that video, it was very disturbing. And I know that we would be a disservice to allow an officer, basically in training, that eventually will be on the street, that will be patrolling the area. And that is very concerning, because the fact of it is there are too many times there has been complaints filed about officers that were ignored, that were dismissed. And the community probably can tell you better than anyone else the probability of an officer pulling a gun and killing someone. I would have rather him taking training, not a jujitsu, but probably in de-escalation and how to deal with the community. And so that was kind of disturbing for me.
Thank you, Ms. Hatcher Crawford. Any other comments? Okay, Ms. Essex, will you take a roll call vote, please?
Clavo.
Aye.
Clavo, aye. Crawford.
Aye.
Crawford, aye. Dole.
No.
And Dole, no. Dudley.
Yes.
Dudley, aye. Glacier.
Aye.
Glacier, aye. Johnson.
Aye.
Johnson, aye. Laura.
Aye.
Laura, aye. The 6 ayes, motion passes.
Okay, thank you. As this was the last item on the agenda, do any of the members of the board have any additional comments before we adjourn? Seeing none, I'll need a motion to adjourn. And a second?
Second, Clavo.
Okay, the meeting is adjourned. I'm going to ask the board to stick around for a scheduling issue. Otherwise, this meeting is over. Thank you.